Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dahil mihi Anglican po, in service of you.
Good morning. Good morning. I'm here. I was almost late, but I'm here. Oh, man. Let's see. There we go. Oh, that's not. I feel a little small this morning. We'll fix this here. There we go. Oh, yeah. I'm growing. Now I'm big. Here we go. All right. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Great to have you here this morning. Not just all of you, but it's specifically great to have 80s Music Man here. I butchered that one. Sorry, 80s Music Man. Is that a little better? Looks a little better here. Especially good to have 80s Music Man here this morning. 80s Music Man has won once again. He's won the internet, and everything IP related is now firmly in your control for the duration of the day. I think you were the winner yesterday as well, so this is a repeat offender for you.
Alex stole it as well.
We'll go ahead and make sure we put that on your record. Thank you, 80s Music Man. Appreciate you being here 2 days in a row. That's a good thing, and it's not an easy task. It really is not easy. Hey, little RA. Oh, little RA came in and said he had something very important to say.
Happy birthday to Harmony Montgomery.
Happy birthday. Harmony Montgomery. Wow. That's a very significant birthday, especially for the case we're following today. First of all, happy birthday to Harmony's a very sad day. Harmony's the little girl who's missing, who the defendant we're following in this case, Adam Montgomery, is accused of her murder. Her body has never been found. But Charmaine, thanks for reminding us of this significant date, especially in this trial. I was going to say my middle child came in and reminded me of something that he whispered in my ear.
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. Welcome to Wednesday. Sorry if, wow, that was a little much. I didn't have that much in me, but I gave it all I got. It is Wednesday. We're halfway through the week. Thank you, Tammy. It is definitely hump day. Let's see. We've got quite a few people here in. Let's see. I need this one off. This one on. Got quite a few people here in the room. Let's see. Katrina sent me an amazing police chase that I want so badly to show. I need to find a better copy because it has a lot of narration over it. I need a clean copy. But I want to show that one. Also, if you missed yesterday, I realized yesterday we said
subject matter jurisdiction.
Well, we were going to, but not right now. Yesterday we were going to have the day off because there was no court. So a lot of you may not have shown up because you thought, hey, I've got the day off. Judge didn't order me to be here, so I'm not going to be here. Well, we still had our live stream, and we covered a police chase. And if you missed that police chase, you don't know what you missed. It was incredible. It was amazing. It was so much fun having all of you there. Just great fun. And it's less than an hour, but it's wonderful. You want to go back. You might want to go back and watch it anyway. I would say this: if you are a secret fan of watching police chase videos, and you don't want to let anyone know, if you are going to sort of out yourself to the public about your love for police chases, this is the video to share with your friends. This is the one. You can go ahead and post that on your Facebook. You can post it. You can share it to someone who sent me the link in an email. This was the one they want to watch, and it will get them hooked as well. It was a great police chase with every officer in the state, I think, was involved. It was really good. All right, we have, let's see, I'm checking to see if we have, in addition to Harmony's birthday today, if there's anyone here in the audience. Is today really Harmony's birthday? I believe it is. Let's see, Laura says, I'm pretty new here. I forgot how you get a gift membership. If you type !gifts in chat, Laura, It will pull up a link you can click on. It's easier on a computer than on a phone, but as long as you're in a browser, you can click on that link, and then you can change the settings to allow gifts on this channel.
Is that correct?
There's the code right there. Anybody can type that. And then as long as it's selected, you only have to do it one time. And then forevermore, if you're eligible to receive a gift, meaning you're not currently a member, and a gift is given, YouTube will include you in that mix for giving a gift or receiving a gift. But let's see, sun is doing its best to shine here, so all's good, says Vivian. It's always good when the sun's coming up. That's wonderful. Let's see, yes, just to make sure you have gifts turned on, and then wait. The waiting part's the hard part.
Now let Murdoch stole it.
Okay, yep. According to the internet, her birthday was 6/7/2014. So sad. It is. It's sad. But if there's anyone whose birthday is who's here, we would like to celebrate that as well. There's the buffer, so I'm probably missing somebody. Let's see. Buffer. Boom.
I'm not a cat.
Abby. Buffer. Tackett. Kathleen Tackett is a member for 1 month today. I missed the message, first of all. Abby, thank you for that. And today is Abby's birthday. Abby is one of our original mods on the channel, one of the original viewers on the channel, has been here for the long haul. Does a fantastic job from all the way across the pond. Even when it's late into the night, she's here. Just incredible. I don't know when she sleeps. But if you share a birthday with Abby, I'm definitely going to sing to you. Definitely going to sing to Abby today. Let's see. Ooh, Homeschool Ground Zero. Is my wife in here? Bing! He's downstairs and I'm upstairs. Still scared me. What happened? I'm looking. Scares me every time. What? I'm going back in time to see what it was. Let's see, we had hump day. Hump day. Sorry, I didn't warn my wife that I would be yelling at the top of my lungs in our house. Sorry, wife, Mrs. R.A., I apologize. Homeschool Ground Zero is my wife. Miss Priss, welcome to the gallery. Again, new courthouse color by your name. Green looks great. I think actually this is the second month you've had a green courthouse, or maybe the third. Been here a long time, but thank you so much for your continued support. And also, Lewis Cox gifted 1 Recovery Addict membership. I'll see if I can find where that one went. Wait for it. Oh, sorry, Siri. I wasn't talking to you, Siri. That one went to Shireen. Congratulations, Shireen, and thank you very much, Lewis Cox, for that. We only have just a couple minutes before we begin trial. I will say we have observers. Let me just double check and make sure I don't call out the wrong people. We have observers in the courtroom again. Let me see. I think I have a picture. Sent an image right here. Let's see.
Alex stole it as well.
I think we've got Lee and Shells. Yep, Lee and Shells are at the courthouse right now. They sent a picture of the outside of the courthouse. Parked outside the courthouse to say, just talk to Legs, the tall prosecutor. They're making the rounds. They're getting information for us. It's going to be wonderful. This is going to be good. Another buffer sound. Kim Newton, welcome to the gallery. Thank you so much. Good to have you. A blue courthouse by your name. Second month there. So yes, Abby's birthday. We need to sing to Abby. It's Kathleen's birthday. My birthday is Christmas. Oh, Abby. I misread your message. So it's Kathleen Tackett's birthday. I think that's what the buffer was about. Let's see. Yep. Abby, thank you very much for straightening me out. I read faster than my brain thinks, and sometimes I think faster than I read, and I think that's what got away with me there. So we're going to sing to Kathleen anyway. So Kathleen Tackett, where are you at, Kathleen? I need to see the message where you outed yourself for your birthday. You might just have to retype it. Let's see if I can find it here. I might have scrolled off the screen. Bummer. Let's see, we got Hump Day. Let's see, I was finally up early enough to say hi to you before Brandy started. Thank you, Dinah. You guys are, I think you're in jury verdict watch in that trial. So if you get bored, feel free to pop in. This is going to be a fun one. We're getting towards the end of this trial as well. There it is. I found it. Kathleen, I found it. Now we can sing. I found the message where you admitted that it's your birthday. So, everyone, this is not just a solo, by the way. This is a sing-along. You guys all know the words. It's a simple song, but we're going to sing to Kathleen and anyone else who has a birthday today. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Kathleen. Happy birthday to you. There you go, Kathleen. Happy birthday. I hope I'm the first person that sang to you today. If not, I hope I'm the best person that sang to you today. Oh, it's great to have you here. Thank you for spending your birthday with us. There are a million places you could be, and it's an honor to have you here with us. It would not be the same without you, but hope you have a fantastic birthday today. All right, we have just moments before court begins, so we're going to keep the audio turned on there. Ready here. Thanks for yesterday's bus chase. Recovery Addict, it made my day. Carol, that was an amazing, amazing chase. You guys were so witty in chat as well. It was hilarious to read the comments. As a matter of fact, my wife and I went back and rewatched. They watched it live. Okay, my family watched it live, but they went back and rewatched the. Wow, they're starting early. We rewatched the chase yesterday and just read the comments, and it was hilarious.
We're qualifying.
Okay, here we go.
Felonies.
Oh, we're qualifying felonies.
That would be.
I have to fix the audio again. We need both channels. It'll be a quick fix. Just 1 second.
4.2C and 4.3C. Oh, okay. And that's consistent with the language that you have in the stipulation. I agree. And then I put the stipulation in at the very end of 4.2C and 4.3C, so I can show you that.
In a second, we'll have full audio on both channels in just a moment.
Copies. I will give you revised copies. You want to see?
Angelina Knox, happy hump day. Thank you so much. Appreciate the 3-month message.
Clicking, I think, what you're saying. So
we're going to make a quick cut here to this one.
You want to see? It's not clicking, I think, what you're saying.
Now let's crank the audio a bit. We'll get it set up. At least we've got both ears now.
We talked about adding the stipulation. So
okay, we're going to do a compressor and limiter. Bring that up. Oh, now they cut the audio. It's a little hard to fine-tune the audio when you cut the feed, Mr. Cameraman. But we'll make do. A beautiful morning here in Oregon. Sounds amazing. My son, who's in the Intermountain West, sent us pictures from this morning as well. It looks beautiful there as well. Miss Johnson, woohoo, new courthouse color. Looks great. My wife's told me, I've been saying this is light blue. She says that's teal. So we're going to have to do a poll at some point. Is this light blue or is it teal? Oh, my goodness. The courthouses are calling in. Love chat and RA, says Bree Cole. Thank you very much. 1 month for Bree as well. Shireen, love our 13th Addict community. I love the combination of the 13th Addict. Let me just say, Brandy is absolutely amazing. For those that don't know, she is. I'm a brand new YouTuber, and she started after me, and she is killing it. She is really killing it. Just doing an amazing job. Love her. Her passion for this is amazing. She's going to go far, really, really far. I'm super excited for her. So thank you, all those who share us between I guess you divide your attention between us. And thank you so much for that. Linda James, yay, 1 month member and staying put. Thank you, Linda. So great to have you here. I appreciate all of you. You're wonderful. And I think I got Miss Johnson as well. Woohoo, new courthouse color. Is it teal? For all the 1 month, let's do 4 people can vote only. Okay, we have Linda James, Shireen, and Bree Cole, and Miss Johnson. Of you 4, I'm not going to do a poll. Is it teal or is it light blue? I'm asking for a friend. Let's see, seafoam green. Oh man, definitely not green. Let's see what trial's up next. I couldn't get into this one. The next one is going to be Scott Peterson.
Roth.
Scott Peterson actually starts today. For those that don't know, Scott Peterson is he says these are the plans. I can tell you what the plans are. He is the security guard at the Parkland school where the shooting happened. And he's being charged with 7 counts of child neglect for failing to go in to try to stop the shooting. Let's see. We had Buttercup just came in as typing on the keyboard. Rebecca, just to let you know, Buttercup is sending super chats again. So thank you, Buttercup. Appreciate that, Rebecca. Pamper Glamper, sorry I've been cheating on you, RA. That's all right. I cheat as well sometimes. I also dip over there for a quick peek at what's going on Brandy's channel. She does an amazing job, and I do not blame you. Thank you very much for being here just for this morning. 4 months, Pamper Glamper, that's great. And Chandra as well. Shout out to the Loft Lurkers. Pop in and say hello. We love you. Chandra, thank you so much. One of our great mods. guys are amazing. It's teal. That is definitely teal, says Karen. Mine's turquoise. I prefer aqua. But what should I call it? I realize you all have your own color. It is turquoise. Tiffany blue. Is it like Caribbean blue or Caribbean, depending on where you're from? Let's see. Shells and Lee just said we saw Matt from Court TV. I think he'll interview us at lunch break, so that could delay phone call a little. That's all right. That's all right. You guys do that first, and we'll check out. Obviously, we can't air the interview of you on our channel. That would be a big no-no. But we want to see you guys get interviewed. Okay, charge the phone. We're good here. Burnt toast. I say teal, and but you have switched from teal. You now have the green, the light green. So thank you very much, Burnt Toast. I appreciate that, but appreciate your vote with your membership anniversary message. Okay, I don't see Shells and Teal, or sorry, Shells and Lee.
She keeps taking my keyboard. What am I to do?
Bite me. Thank you very much. You need to lock up your keyboard when you go count mosquitoes. That's what we need to do. They are saying they've got a new cameraman today. Interesting. New cameraman today. We'll see how that changes the style of the shooting, or the video shooting. Buttercup has spent all of Bite Me's dollars. We already did do Hump Day. It was early on. My voice may not recover. Yep, new cameraman today. Thank you. Lee's in chat as well as in text, so I appreciate the double contact. I see closing slides on computer. I'm guessing state rests right away. Where's Ish? Man, Shells, I don't know. You guys are seated in a different position, so you might be over on the defense side. That would give you the view of the computer right now. But Jess Dawson, good morning. Good to have you here. New cameraman, no more close-ups. Maybe we'll get to see the lawyers, namely the tall one, as they ask questions now. Well, there he is right now. And he is I won't say freakishly tall, but he is amazingly tall. Like, he's got, like, giant genes in him. Can you tell me what part Ish plays in this? Mary, I wish I could. Everyone's been talking about Ish as this big, scary guy, a provider of illicit drugs. Why is Siri so interested in whatever I'm saying right now? I don't know why it keeps talking. Anyway, so he provides drugs. He buys and trades weapons. He's not. Oh, there's Shells. Shells is just off camera. He's a scary dude, and everybody knew him. Let's see. Still no audio from the courtroom, so give us just a minute. I've got to do some more tweaking. Defendant is not present yet, and neither is the main defense attorney. They might be together. Main defense and main prosecutor might be together working something out. Yeah, Ish is the final boss on this game, I think. That Carrie Brook, that is 100% correct. Oh, you missed yesterday? Rosebud, you did not miss anything from this court, but you missed one amazing police chase. It's well worth going back. It's on the, it should be on the playlist if you can't see it for some reason. Oh, we're getting camera dropouts. Let's see. I can't tell what's happening. Now the camera feed's dropped. Okay. They completely cut off the stream. Man. New cameraman pulls the plug day one. We want our old guy back. Let's see. Let's let Lee know really quickly. Stream cut out. So we'll see. Hopefully they get the feedback in just a second. Picky says, that bus chase was the best ever, and your music you picked made it to a new level. Recovery Addict, you did a great job. Thank you, Picky. Share it with a friend who would appreciate that. other people deserve a good laugh as well.
Is that correct?
That's correct. A very good chase yesterday. Thank you, Heather. Appreciate you being there. The bus, yes, it was amazing. Let's see. Is this Harmony Montgomery's dad? Yes. That's who we're talking about. But the trial we're dealing with is not Harmony's murder trial, or the murder of Harmony. We're dealing with a guns violation, a weapons violation that they found while they were investigating Harmony's disappearance. So that's where we're at with this one, and we're almost done with it. Okay, still no feed right now. Oh, we've got bars. Now at least we've got a feed a little bit. Bars and tone, and we've got a connection. Wait. Sorry. We need 3 here. 3,
I'm not
2,
a
1.
camel.
Waiting for a connection, and there it is. Okay. Looks like we moved the camera a little bit, but he completely unplugged everything to do that. At least zoomed in. Still no audio. Watched it last night and loved it. Thank you. So thank you, Brenda. That was fun. We don't often get chases of that caliber, and it was.
I was kicked back, taking it easy.
Well, what more I need to see? I need to see what's happening in court. That's what I'd like to see. Oh, Sharon, the worst during that bus chase was when he's going over the corn rows in the field, like at 80 miles an hour, and you can just hear like the hubcaps falling off the car, and just like parts are just shaking loose. Jury. And the camera, if you watch the camera in the car, when it starts out the chase, it's nice and level, and by the end we're like tipped. It's like everything's falling loose in the car. Here we go. I think they're bringing in the defendant right now. Pauline, I'm not sure for a couple of reasons. The schedule is a bit tricky time of year. There may be.
Is that correct?
We'll have to see when BK's case actually moves forward. We've already got a date for that, but I'm not sure if it's going to push or overlap or something. See, school bus, flying bits of cornfield, about 100 police cars, funny comments. What more do you need to see? The chase was great. Okay, we're about ready. Oh, we'll do water. We'll water while we're waiting, and then we'll turn off the sounds here in just a minute. Have the blue mug today to match the shirt. You're right, it is a freeze frame, and we're losing the connection again. This new cameraman is struggling. And here it goes in 3, 2, 1, 0. It's going to go to black. Boom, it's gone. Yep. The feed dropped. So we're going to do water while we're waiting. Alrighty. Oh, that is really good. See if we have another.
I'm not
option.
a camel.
Recovery addict, love my new pick with you in background.
Awesome. That is a great pick. You've got the mug and me in the background. That was that's a feat right there. That's like next level photography. Janique, thank you very much. I appreciate that. We're getting the feedback. They're just sending bars and tone right now, which is what they start the feed with, just to calibrate and give us 2, 3, 4, and 5.
I was kicked back, taking it easy.
Come on, there we go.
You're in the State House, Detective Jack.
And we've called a detective first. Janique, by the way, thank you for your super chat. I appreciate your support of the channel. It makes all this possible, and it means the world to me. Day is now complete. Tammy, I'm glad I could make that your day wonderful. Let me still work on this audio.
You're about to provide will be the truth and nothing but the truth, and any thanks and penalties of perjury.
I do.
You can make yourself comfortable. Can you start by stating and spelling your first and last name for the record?
Sure, it's Detective John Dunleavy, JohnDunleavy.
And is John the name that you go by?
It's my legal name. I go by Jack.
Okay.
And now at Murdoch stole it.
Detective Dunleavy, how are you currently employed?
With the Manchester Police Department.
Since when?
2015.
Since when?
And what is your current case assignment with the Manchester Police Department?
Currently, I'm assigned to the Juvenile Investigation Division.
And are you a detective with the Manchester Police Department?
I am.
How long have you been a detective with the Manchester Police Department?
Since 2018.
And what are your duties as a detective?
I handle all of the physical and sexual abuse of children in the city.
Oh, man.
And so you mentioned your time with the Manchester Police Department. Any prior law enforcement experience?
I was with the Winchester, New Hampshire Police Department for about 2.5 years.
Prior to that, did you graduate from the police academy?
I did.
What year were you?
What was your class
2013.
number?
And what class?
162nd.
I don't know why they ask that, but it's interesting.
Can you, just briefly for the jury, describe your role and involvement with this case?
Sure. So for this case, I'm one of the co-leads with Detective Rahill for this case. My involvement started about February or March of 2022.
You mentioned Detective Rahill. Is that Max Rahill?
It is.
And you said that you're a co-lead with Detective Rahill?
I am. He's my partner.
Were there any other Manchester police detectives that worked on this case?
There were dozens.
Were there other law enforcement agencies involved in the investigation of this case?
There was.
How many would you say?
The FBI, ATF, the U.S. Marshals, Department of Corrections, the sheriffs.
Did you participate in interviews for this investigation?
I did.
How many people would you say you've spoken to or interviewed in this case?
Dozens.
How many hours have you spent investigating this incident?
Hundreds of hours.
And are you familiar with the defendant in this case, Adam Montgomery?
I am.
Do you know who he is?
I do.
Did he at some point become a person of interest in this investigation?
Yes.
And do you see him here today?
I do.
Can you point him out?
Sitting with a white shirt next to his attorneys.
And can the record identify that the witness has identified the defendant?
The record shall so reflect.
This camera is using the rule of thirds.
Were you the original investigating officer on this case?
I was not.
And can you just tell us how you became involved?
I became involved it was like late February, early March of 2022. Myself and Detective Rahill worked on the case together.
You mentioned that at some point the defendant became a person of interest on the case.
That's right.
And what led your attention to the defendant?
There was information that had been obtained through Kim Frayne identifying him as a witness.
Was one of the individuals that you interviewed in relation to this case a gentleman named Mark Reed?
It was.
During your interview with Mr. Reed, did he consent to a search of his Facebook account?
He did.
And did you review those messages?
I did.
Were you able to locate an account identified as Adam Montgomery's?
Wasn't able to identify the name. I was able to identify the Facebook URL.
And was that a number combination?
It was.
Associated with a deleted account?
Yes.
And so you weren't initially able to identify the account associated with that conversation?
No, it had been deleted.
Were there statements within that communication that led you to the identification of the person that Mark Reed communicated with?
Yes.
And can you tell us what that is?
Through the messages between that deleted account and Mark Reed, there were audio messages. There was the mention of 77 Guilford Street. There were phone numbers associated with the Montgomerys. There was a photo of a family pet that they had with one of their children laying next to it, which was associated with one of their other Facebook accounts. Things of that nature.
And when you say their Facebook accounts, they had, who is they?
Adam and Kayla Montgomery.
And you mentioned 77 Guilford Street. Are you familiar with that location?
I am.
And who do you believe to have lived there back in October 2019?
So in October of 2019, it would have been Adam, Kayla, Declan, Seamus, and Harmony.
You mentioned one of the phone numbers, or you mentioned several phone numbers associated that led you to Mr. Montgomery. Was one of those numbers 603-858-5597?
And we're glitching again. Let's see if I can take a different feed for a minute.
Were you able to locate an account identified as Adam Montgomery's?
It's delayed.
Wasn't able to identify the name of 2019 in that message exchange between that deleted account and Mr. Reed.
During your participation in this investigation, did you interview an individual named Kevin LaBelle?
I did.
How many times did you speak with Mr. LaBelle concerning this investigation?
3 times.
Did you meet with him on April 28th of this year?
I did.
What was your purpose of meeting with him?
Detective Ray Hill and I had met with him at the state prison to ask follow-up questions in relation to the gun case that we're here today for.
Prior to speaking with him, had you also received information from Kayla Montgomery?
I had.
Was that one of the purposes for speaking with him?
Yes.
What was your goal there?
To corroborate the information that she had stated to Mr. LaBelle.
And as a detective, why is corroboration important?
Credibility.
During your interview with Mr. LaBelle, well, can you just describe what that looked like, this last interview that you mentioned on April 28th?
Sure. So the purpose of us going there was just to clarify, that in particular, and then ask any follow-up things. Basically the way the interview started is I told him, we're not here to talk about...
She said, I think we're going to hearsay.
I'll rephrase the question, Judge. Did you sit down with Mr. LaBelle at some point?
I did.
Did he offer you information without being prompted?
Sustained.
Wow. It was a yes-no question, and it was sustained for hearsay. Did he offer you information without being prompted?
I want to switch gears, Detective Dunleavy. You mentioned 77 Guilford Street, that you were familiar with that address. What sources of information did your familiarity come from?
I knew that there had been police reports at that address with the Montgomerys during that time period.
And were you aware of an eviction?
I was.
I don't know this detective's name, but he is a detective.
Did you interview multiple people from the Guilford Street address that were living there at the time?
I did.
During the course of your investigation, did you review Facebook records related to an Ishmael Garcia?
I did.
How did you obtain those records?
Through a search warrant.
Did you look specifically at any specific, or did you look at any specific periods in time at those records?
I did.
And in those records, were there any messages regarding the sale of guns, the sale of firearms?
No.
Okay.
Objection?
Which may we approach?
Yes.
The defense has been very, very quick with objections. Clearly there's an area they do not want to go into. The defense doesn't want to go into, and there's an area that the prosecution cannot go into. And we're seeing that line getting closer and closer as this detective was not investigating him for firearms. That was not what it was there to do. His investigation is clearly about something else. We know that based on what he's testified his job role was. And now they're saying, while you were doing your job, did you find information about firearms? And they're objecting. They've objected to hearsay. We don't know the basis of this particular objection, but the judge has been sustaining these objections pretty quick. So we'll see how this turns out. The state is going to argue this point. They haven't. I thought they should have argued the previous hearsay ruling, where there was a yes/no question. Did this happen? Did someone provide information to you?
Sustained. The last question and answer are stricken.
Holy cow! This is the guy that found the evidence of firearms, probably the reason why this whole case is beginning. He's provided the foundation for why it happened.
You mentioned that you reviewed those records during a relevant time period.
I did.
And what was that time period?
I believe it was the September 28th, 29th until October 4th, 5th. I went a little bit further out.
At some point, did Mr. Garcia become a person of interest in this investigation?
Not for the theft of the firearm or the rifles, no. Or the shotgun and the rifle.
During the course of your investigation, did you review a cell phone extraction from an individual named Jonathan Sargent?
I did.
And during your review, were you able to identify contacts stored in that cell phone device?
I was.
I think. Approach?
Oh my goodness. Even the detective was like, you're serious? You're objecting? The question was, he basically finds a bad guy, finds his phone, and during the investigation looks at the contacts on the phone. And the question was, were you able to identify contacts on that device? And she objected. Like, wow. There must, I don't know what the pre-trial ruling was, but it must have been very broad to not allow anything near this in. But they're not even allowing the foundation for this case and how it, how they discovered that he was selling and stealing firearms. Good morning, New Bunk Foss. Good to have you here. It's a great day. Happy Wednesday to you. DMB, thank you for that. I'm going to go ahead and pin that one. So we're listening to Detective John Jack. Jack is his name that he goes by, but John is his legal name. Dunleavy, who's a state's witness. He was investigating Harmony and her disappearances and circumstances around that when he discovered the firearm transactions on Facebook, apparently. But so far, the judge has not allowed any of that in. Let's see. Clipson's Vixen says, I missed you all so much. Hope to get back to normal very soon. Love and miss you all bunches. Thank you, Amber. I hope everything's going well. Take all the time you need. We'll be here when you get back. Happy 4 months. Congratulations, Amber. The jury will be getting ticked, like defense trying to not get him to answer anything. Yeah, can you imagine what Cross is going to be like on this one? I try not to think about that because how painful it was previously in the last couple days. Shar, trial watching queen, member for 2 months. Thank you very much. Appreciate that. You've got Green Courthouse now. Congratulations on that third color. If police didn't have a warrant to search for the phone, then the contents of the phone could have been excluded as fruit of the poisonous tree. Great point, Matthew. Warrantless search, any evidence it produces is not admissible. Fruit of the poisonous tree. Let's see if that's what it was.
So, Detective Dunleavy, I'm just going to back up and recap. I think you testified that you had reviewed a phone extraction related to a Jonathan Sargent.
That's correct.
If they have an extraction, they must have had a warrant. This must have been a foundational
And you said
objection.
that you had reviewed the contact information associated with that extraction.
Yes.
It's got to be foundation.
In that extraction, was there a phone number that you were familiar with?
There was.
And what was that phone number?
603-858-3393.
8675309. Sorry.
And was there a name associated with that phone number in Mr. Sargent's phone?
Overruled.
Sorry, was there a name associated with that phone number in Mr. Sargent's phone?
There was.
And can you tell the jury what that name was?
Adam Montgomery.
If I may approach the witness, Judge.
It's me?
I don't know who just dropped their pen on the desk, but it sounded like out of frustration.
So, Detective Dunleavy, you previously testified that you were familiar with Mr. Reed's cell phone conversation with the defendant.
Correct.
And I'm going to ask you to take a look at that.
gigantic picture of a
Can you
phone.
hold that up for the jurors to see?
This is how New Hampshire does screenshots
And can you
of
point
phones,
to the
guys.
number that you recognized on Mr. Sargent's phone?
Right down here at the bottom.
And can you read it to the jurors in the back?
I can read it.
603-858-3393.
Did you search for any other numbers or contacts on Mr. Sargent's phone?
I did.
Who did you search for?
Ishmael Garcia, Hector Rivera Ayala.
And did you also look under their aliases, known aliases?
I did. I looked under Ish. I looked under Manny.
Did those searches yield any results?
No.
I want to switch gears and talk about another role that you have as a detective. Do you have access to phone calls made by inmates at the House of Corrections here in Manchester?
I do.
Can you listen to those calls as they're occurring?
I can, yes.
And can you tell me about those calls? What happens when you press play on one of those calls?
As soon as the inmate would pick up the phone and start entering their PIN and associated information, the recording would start through the jail, and I would pick up that, and then as soon as the phone call started, it would also start recording that until either the caller or the person that received the call hangs up, then the recording would end.
And you mentioned a PIN just now. What is a PIN? What did you mean by that?
A PIN allows the inmate to access their account, so nobody else can use it.
So that's a specific identifier?
It is.
And that initial message, does it provide the name of the person in the House of Corrections that's making the phone call?
It does.
And you have access to records held by the House of Corrections here?
I do.
Are you able to review those records at or near the time that they're created?
Yes.
Those records with the House of Corrections, are they made for every call that goes in and out of the jail?
Certain calls are private and not accessible to law enforcement, such as attorney phone calls and calls to treatment facilities, such as drug or alcohol rehab.
So calls with a privacy interest you wouldn't have access to?
Correct.
No, the judge has just allowed a single video camera for this trial. So we only get one vantage point. We'll zoom out here for a little. Let me show you. I'll just telepathically have him zoom out for a bit so you can see the setting. There we go. We're connected.
And Detective Dunleavy, I'm handing you, it's been marked for identification purposes as State's Exhibit 43, and I'm going to ask you to take a look at that. Do you recognize what that is?
I do.
What can you tell us what it is?
This is a portion of a jail call with Mr. Montgomery and his father.
How do you know that?
Because I've listened to every call that he's ever made, and I know from reviewing this that this is that call.
Do you see something that indicates that you've reviewed it?
My initials in top left corner.
And is that a fair and accurate portion of that recording that you listened to?
It is.
Your Honor, at this point, I'd move to strike the ID. Mark is full.
Any objection? No, Your Honor. The ID is stricken. It's entered as a full exhibit.
You said you're familiar with you said you've listened to every single one, essentially.
Yes.
You're familiar with the defendant's voice?
Very much so.
You've had personal interactions with them related to this?
Yes.
Your Honor, I move to publish.
So we said, are you familiar with the defendant's voice? He said, very much so. You've had personal reactions related to this? Yes. Taylor, congratulations. I think that's teal. I think it's teal. Light blue, teal, seafoam green, one of the two. Welcome to the new courthouse color. Ooh. I think he spilled. A little ASMR water. Our courthouse observers have not seen Ish in the court yet. He obviously won't be in the courtroom right now, but they didn't see him outside either.
20 years ago, whatever, supposedly this fucking girl, her house was broken into, but it wasn't he's going chilling. You asked, I was at her house, he was chilling, boom, whatever. She was going to bed, boom. She was going to sleep, falling asleep. I was falling asleep and waiting for this kid to come back to the fucking house. I'm like, all right, yo, I'm out of here. All right, cool, boom. I'm jetted.
Okay, I've got the Kersey counter going, but I'll put it up on the screen. We're up to 14 all of a sudden. That happened quick.
You've heard that portion of that audio clip before, correct?
I have.
And was that the defendant's voice we were hearing?
It was.
Do you know who he was speaking to?
His father.
And at the beginning of that call, does it say this is Adam Montgomery?
Yes. Before every recording, the person has to identify themselves by name. And my understanding of their calls is if that name isn't recognized in the call, it won't go through as another added layer of protection to make sure that the inmate's actually the one making the call on those accounts.
Detective Dunleavy, I want to switch gears again. Are you familiar with common terms that individuals use associated with drugs?
For the most part, yes.
Are you familiar with the term TINA?
I am.
What does TINA mean?
Crystal methamphetamine.
Ooh, Tina is crystal meth? That's new to me. I did not know that.
Detective Dunleavy, I don't have any additional questions for you. I believe Attorney Smith may.
Thank you.
I do. Good morning again.
Morning. Good. How are you?
I'm okay. So let's start with that phone call. Went kind of quick. And I don't know how much everybody picked up, but you've listened to it for a lot, right?
I've listened to it before, yes.
And that recording started out with a dude fucking 3 years ago, bro, 4 years ago, whatever, fucking, supposedly this fucking girl, her house was broken into, right?
That's what I heard.
Okay. And so after he said, supposedly this fucking girl, her house was broken into, but it wasn't broken into, me and her were chilling, I was at her house, we were chilling, boom, whatever, right?
I believe that's what I heard, yes, if you're repeating it verbatim.
Okay. And,
we were repeating verbatim.
That's what you heard over the times that you were listening
yes.
to it, right?
Yeah.
And it continued saying she was going to bed, boom. Me and she was going to sleep. She was falling asleep. I was falling asleep. We were waiting for this kid to come back to the fucking house. And I'm like, all right, yo, I'm out of here. All right, cool, boom, I jetted. Is that what the recording said?
Yeah.
So he is talking to his father. And he's talking about something that he said happened 3 or 4 years ago?
That's what it sounds like.
Okay. And he's saying supposedly this girl and her house were broken into, right?
That's what he said.
Okay. And this occurred after he was arrested, right?
This jail call?
Uh-huh.
Yes.
Okay.
He was in custody. It was a jail call.
All right. So I want to move on from that call to some of the other stuff that you've done in this case. Michael Sullivan is someone you are familiar with from this case, right?
That's right.
And in March 7, 2022, you accompanied Detective Ray Hill, members of the U.S. Marshal, and task force members to a location in Massachusetts, right?
Correct.
And you were there to serve a warrant, fugitive from justice warrant, and pick up Michael Sullivan, right?
I was not. I do not have powers of arrest in Massachusetts.
The purpose of being there was to get him arrested on the fugitive from justice.
Correct.
But you bring other people from Massachusetts who have the power to arrest him when you went to Michael Sullivan's, right?
Correct.
But the purpose itself was to arrest him, right?
Yes.
And that was March 7, right?
I don't know the date off the top of my head, but that sounds accurate.
Okay. If I showed you a copy of a police report in that regard, would that help refresh your recollection?
Sure.
Yeah, I'm getting lots of requests to remix this into a rap song, of course with the edits. I've done that in the past. I actually...
Show you
I edited audio
report. I'm
for.
sorry for my highlighting. You don't have to check totally my highlighting.
No, that's okay. Yeah, I see it says March 7th, yeah.
Okay, does that sound right about the time that you accompanied Detective Rayhill, the U.S. Marshals, and a task force to Mr. Sullivan's home?
Yeah.
Okay. You did not arrest Mr. Sullivan at that time, right?
No, we did not locate him.
You did not have any contact with him, right?
No.
You were not able to locate him, right?
Correct.
And his wife was there, right? Or a female was there, that somebody within the group that was there talked to, right?
His significant other, yes, she was there.
And then on March 31st, you spoke to Michael Sullivan, right?
That sounds accurate.
Okay. If I showed you a police report, would that help refresh your recollection?
Sure.
Sure. Show me the report already.
Show you a copy of a police report. If you review that and let me know if that helps refresh your recollection.
Yeah, that's accurate.
Okay. So March 31st, you interviewed after he had been arrested in Manchester, right?
Correct.
And again, he was arrested with the full task force, or U.S. Marshals, and several police officers, right?
I don't think that's accurate. I think it was just the sheriff's department.
We're seeing a buffer. Anybody hear me? Is it working?
Okay. And he was brought to the station, and you spoke to him with Detective Rayhill.
Yes.
And so if you went to arrest him in Massachusetts on March 7, you didn't talk to him on March 8, 9, 10 through the 31st, right?
Not that I remember.
You were actually looking for him, right?
I'm not sure how active we were looking for him, but we were obviously keeping our eyes out for him.
Right, you still wanted to find him, right?
Sure, yeah.
Okay. And when you spoke to him, it was a lot more than 24 hours after somebody spoke to his significant other in Massachusetts, right? On the fugitive warrant when you were there early.
Can you repeat the question?
I really have to.
That's all right.
March 31st was a whole lot more than 24 hours after you went to Massachusetts to try to have him arrested on that fugitive from justice warrant at his home.
Yes.
And after you spoke to Michael Sullivan on March 31st, a fair amount of time had passed, but you eventually talked to the Hillsborough County Attorney's Office about Mike being useful in the investigation, right?
Right.
The Hillsborough County Attorney wanted to know if indeed he had been useful so that he could determine what to do with the case, right?
You'd have to ask that attorney.
Okay. But he contacted you to ask if indeed Michael had been useful.
Yes.
And you, in this investigation, worked with the Attorney General's office as well, right?
That's correct.
Okay. And
she has
you
nothing to
spoke
ask him because she
about-
objected to everything he wanted to testify about. swear, if she goes into the same area that
Mr.
she objected to.
Sargent's phone and what it contained and what it didn't contain, right?
Repeat the
On
question.
direct, I'm sorry.
Sorry, repeat the question.
Mr. Sargent, you spoke about his phone and what it obtained and didn't obtain, right?
I spoke about the contact information that was in there, yes.
And Mr. Sargent was arrested October 22nd, 2019, right?
Yeah, the 20th or the 22nd stick out in my mind, but yes, that sounds right about the time.
And that was a little over 2 weeks after an AR-15, a .380 Ruger, and a Mossberg shotgun were reported stolen, right?
Right.
And as far as you know, Mossberg shotgun was not, you know that the stag was located at his place on October 22nd, right?
Yes.
And the .380 Ruger was not located at his place that day, right?
Not that I'm aware of.
And the Mossberg shotgun, also reported stolen from the Frames, was not located there that day, right?
Correct.
But the .380 was subsequently located, right?
Correct.
And did you attend?
Basis?
She said basis, which basically is the same as grounds. They're going to approach and talk it over. It's funny because it seems to be the defense is going into areas closer to the discussion about the firearms than the prosecution was allowed to go in because the defense objected. I'm hearing that Judy, let's see.
Is overruled.
Does Cynthia and James, are they in court again today? If somebody could find out for me, that would be awesome.
Did you accompany Detective Rahill to Massachusetts after the discovery of that gun?
To Massachusetts, I've been to Massachusetts many times. For what in reference are you speaking of?
Regard to the .380 that was located.
No, I did not.
You also said that, well, one of the other Facebook accounts that you at least did a preservation request for the Facebook account of Anthony Badero, right?
Correct.
And he was known through this investigation sometimes as Tone, right?
Correct.
Okay. And I may have a moment.
If somebody could send me to the burner phone a link to wherever Cynthia and James are going to show up in court, if that's going to happen today, I'd love to be able to catch that and record that. And I cannot remember what court they were in. My old brain just is not working that well.
Thank you very much, Detective.
Well, after circling around the issue and not making a point, she went ahead and wrapped up.
For this witness, I'd ask that he be excused.
You may step down. Any
Please be
objections to being
Please be
excused?
No.
Thank you, Your Honor.
They're excused. Does the state wish to call any additional witnesses?
Your Honor, the state would ask with regards to the second stipulation that the parties have entered into. We'd ask for that stipulation to be read to the jury at this time.
Are they done? No ish? You're ishing me. Reading a stipulation.
Ladies and gentlemen, the parties stipulate as fact that at the time of the allegations in this case, the defendant had previously been convicted in this state or any other state of a combination of 3 or more qualifying felony convictions as listed under the applicable law. I'm going to read that again, ladies and gentlemen. This is an agreed-upon stipulation of the parties.
Basically, he committed
The parties
felonies before.
stipulate as fact that at the time of the allegations in this case, the defendant had previously been convicted in this state or any other state of a combination of 3 or more qualifying felony convictions as listed under the applicable law.
Thank you very much.
They both agree he's got a record.
Having all those witnesses, the state rests.
The state
Okay,
just
very
rested.
good, thank you. Counsel,
No
please,
ish.
for just one moment, please.
The state went without ish. So we had two witnesses apparently who wanted to plead the fifth, who we never saw, were taken care of outside the presence of the jury. We have Ish, who we were promised, who showed up even at court one day, we believe, and then did not deliver. And now the state's done. They say we've proved our case. Ish is not in jail. I wonder if defense will call Ish. They're the ones who've been talking about him nonstop. Yeah, I'm going to ask for a refund, Eileen, as well. Who are Cynthia and James? Kelly Evans. We were doing court hopping, jumping around to little courts, little appearances, arraignments, and things like that. And we came across a trial where an older couple.
The state has rested its case. In speaking with the lawyers, it's possible that this case will get to the jury before lunchtime today. We still have a number of things to accomplish, but it is possible. When that happens, we don't have you take your normal lunch break. We actually order lunch for you, and we have you eat here. So in the event that this case does get to the jury, I'd like to have your lunch ordered for you. So what I'm going to do is we're going to take an early mid-morning break, and I'm going to send you into the deliberation room. Our jury clerk will come up and take a lunch order. Then we'll come back in to resume evidence. After the evidence is concluded in the case, we'll have closing arguments and instructions. That may or may not happen before lunchtime, but either way, you'll have your lunch. I'm gonna send you out now. We'll get the jury clerk up to take your lunch order. We'll bring you back in to resume the case. All rise for the jurors, please.
We may not have any. Hey, there's cells right there. I think we may not have any defense witnesses. This is nuts. Now, based on what we're hearing from Lee, by the way, the jury gets antsy every time defense gets up to talk. It sounds like the jury is sort of favors prosecution. 2 jury watches in one day. Can we beat the other case? Can we come in with a verdict before the NFL case does? That's my question. Kathy, it's so tangled. It sounds like a lot of the evidence they wanted to bring in goes too close to the Harmony case, and so they've excluded it. I wonder if they've done enough. I think in the mind of the jury, they've probably done enough here.
Right.
We're almost ready for a poll. I wasn't expecting that right
Anything
now.
we need to do, or are you just ready to take a break?
We can do the motion before the break or after the break. I actually have 2.
Okay.
This is the directed verdict motion.
Let's go ahead and do them now.
We're going to be starting Scott Peterson here soon, so we should get lunch too, at least. Just make it quick.
My first is a motion to strike certain evidence that has been presented in this case by the state, and it is with regard to the video of the movements of the party of people who have been identified as Kelsey Small, Kayla Montgomery, and Adam Montgomery, and putting the phones into the Echo ATM and eventually the phone being recovered. And I certainly understand the relevance of this phone was recovered from the ATM and its address matches the read messages. So that's relevant. However, and I will tell you that I had questioned the relevance a few times, but it was for the state to make their own argument. And I think that they made the argument with regard to the relevance of the Echo ATM and the deposit of the gun, recovery, the deposit of the phone, recovery of the phone, and linking the phone to the read messages and otherwise. However, you will recall that the state spent a significant amount of time reviewing the remainder of the video with
I'm with her on this.
With the witness,
Not
Mr. Dobe, and talking about going through aisles and what they're doing and focusing on the witness here, on I believe it was Kayla and Adam here, and Kayla and Adam there, and where they're going here, and where they're going, and how long it takes. And I did not see them make any relevant connection between those activities and the relevant activity of the phone being deposited. And I'm concerned that in this sense, without them being able to make the connection to relevant activity, that the activity is really just sort of character evidence of Mr. Montgomery going around the store with Kayla, and perhaps references to how they were communicating with each other or something when there's hand signals and the like. And I don't think that that has any relevance to this case and is impermissible.
What kind of character evidence do you think that is?
That the only relevance that I can see is them trying to make a connection with disputive behavior between them, where one person is moving in a direction, the other person follows, and there's hand gestures. And again, I could not object because there was relevant information on that CD, but I believe that the state had it impermissibly admitted for an intent to argue character evidence in closing.
There's no intent of arguing character evidence. The reason that you had the initial video, obviously the Eco ATM, which is the transaction of the defendant trying to get rid of evidence that links him back to this crime. The other videos that were shown to the jury, there was one from a middle view, and then there were ones that were from the close-up view to show the identity of the defendant as being that individual who was seen before. As Your Honor will note, other than the initial video at the Eco ATM, none of those other videos were shown a second time. We went through them one time to establish identity of the folks that were there. And the state is not intending to argue any sort of character evidence from that in its closing. The weight of the evidence and the reason for its admissibility and the reason for being played is showing the identity of the defendant, getting rid of the evidence there, that he is the one controlling that evidence being put into that Eco ATM, even if it wasn't his name that was on that. That is it. So in terms of character evidence, I'm not too sure what else could possibly be argued from that. In addition, that video was exchanged a very long time ago, and if this was going to be a 404B issue, you should have had this a long time ago as well. That particular CD was marked at the day of pre-mark multiple weeks ago.
All right.
I don't see the argument for it being character evidence, let alone the time.
The court does find that it has relevance for the issue of identity. It does appear that that is the purpose for which it is being offered. The court does not see the video as offering character evidence. And even if you could construe any portion of that as character evidence, certainly its probative value is not outweighed by any substantial prejudice, or any prejudice, frankly. So that motion is denied.
Okay, next comes the directed verdict
Yeah,
motion.
I come to the motion to dismiss charges. Again, the argument is the test that must be considered here is taking the evidence in the light most reasonable to the state. Could a jury find beyond a reasonable doubt that the state had proved its convictions? Proved its indictments. Sorry. The credibility of a witness is for the jury to decide, but at some point I think it plays into whether or not the state has met its burden. The state has, let's start with the theft of property. The state has essentially relied on inferences from witnesses that are not credible based on the fact that they have changed their testimony, that they have provided false testimony, and that there actually isn't a witness that said he stole these from the house, with the exception of Kayla saying that he purportedly made admissions to him. When the guns were taken, we don't exactly know from Kim Frane's representations at trial. She says that she was not aware of what happened to the guns, that she woke up and that they were gone. We have a frame of reference for when the guns were taken from the home and not returned, which is Chris Frane leaving on September 29 and returning on October 2nd. So we do have a time frame for when they went missing. Other than that, the only person who makes a claim that they went missing on the night that Adam went over to see her is her, and again with the purported admissions by Kayla. So she's not saying that the weapons were taken at that time. She is not saying that Adam took the weapons. She's not saying even that the guns were gone in the morning when she woke up, because she claims that she didn't know the guns were gone until Chris came home, which was that evening. So I don't think, given the lack of credibility of the witnesses produced, I didn't talk about the lack of credibility of Kayla, is similar. I'm sorry, it is a credibility issue, but I think at some point credibility has to come into the assessment of this case and whether the state can prove beyond a reasonable doubt
the jury to
that Adam
determine
removed the AR-15 and the Mossberg shotgun from the home. There is a second set, so that would be with the first two sets of first two indictments of theft, one for the Mossberg, one for the Stag AR-15. Then there are two for receiving. And for receiving, we've reviewed the jury instruction that somebody has to have some level of control over the guns. It's not mere possession. Well, possession will do, but there has to be a level of control where the person can control the outcome. I think that there is significant evidence in this case that these guns were sold, that Adam participated in assisting in the sale of the guns, but by reaching out to other people to see if they would purchase it. The presence in the home alone will not satisfy the receiving part. He has to have some level of control in the home, and I think that there's an equal argument that Ish and Manny were in the home with control of the guns and control of who purchased the guns, and that there's no evidence that they would have relinquished the guns to Adam Montgomery, although there is evidence that the guns may have been in the home for some short or long period of time. There are both claims, but I think that without showing that Adam had control over the guns, that state cannot meet its burden on the receiving charges. With regard to the armed career criminal, again, the only issue is possession or having under his control the shotgun, and then on the other charge, the Stag AR-15. There is no, the evidence that he touched or controlled or possessed the guns similar to the receiving charge. Add into it Mr. Sullivan's claim that at one point he sold the AR-15 from the trunk of his car, pulling it out of the trunk of his car and taking it to Mr. Sullivan's home, subsequently putting it back in the trunk of his car, taking it out and providing it to this mystery buyer. Would be evidence of certainly possession and control. And his subsequent statement that those events occurred, but they were the shotgun, not the stag. His changes and inconsistencies in testimony, and his motive to cooperate with the police in order to get the deal that he ended up getting, which was his charges dropped. The level of credibility with regard to those charges, again, the state cannot meet its burden through the witnesses it has presented and the testimony it has presented. Thank you.
Thank you.
I think that's a weak argument.
The evidence has to be taken in the light most favorable to the state, not most favorable to the defendant.
No, it's all set. Thank you.
It has to be taken in the light of the evidence most favorable to the state, not in the light inferences most favorable to the defendant. Here, the evidence has shown that the state can meet its burden of proof beyond a reasonable doubt that the defendant committed each one of the crimes that is charged. The testimony of Chris Frame and Kim Frame were shown that it was two long guns, the Mossberg 500 and the Stag Arms AR-15 rifle, both taken while Chris Frame was away from the home between September 29th and October 4th. We know that the Stag Arms rifle was recovered by
The defense or prosecution is going over their evidence, what they know, what they presented, and saying you have to allow the jury to weigh this evidence. We can barely hear it though.
Also being found with several other firearms and 2 pounds of methamphetamine. In addition to those 2 pounds of methamphetamine, Your Honor, you also have the consideration of the text messages involving Mark Reed, and Mark Reed finding out that
whose phone was that?
4 days.
Shells, Lee.
That he was flush with up, down, and Tino, which we know now is crystal methamphetamine. It's a fair and reasonable inference for the jury to be able to put together where did the defendant get the up, down, and Tino.
We can't hear it. We can't hear what he's saying. It's just mumbling, but he's going over each of the pieces of evidence saying, we have proved the case. We've done enough. You have to look at this in a light most favorable to the state, and so dismiss this charge. This is pretty much routine.
When he went to show them, and it shows that the guns were not lent out or taken without permission from Kim Frame, the way that was implied by defense counsel's questioning during her testimony, that she was asleep in her house and woke up to find the back door open and the defendant gone. That's corroborated by the defendant himself, again, saying in a recorded phone call that he was at Kim Frame's house and that she fell asleep. Not that she crashed, she fell asleep, and then he, quote, jetted, which we just heard a moment ago. Those are inconsistent stories that he then tells his wife, Kayla, and in one of those, the latter one, where he admits that he was there and she was sleeping and he took the guns. It's not disputed that he offered to sell the 2 guns to Mark Reed through Facebook. It is not disputed any of the details of those text messages, in which case he specifically states that his reason for sale is that they need the money so that they do not get evicted. Not Ishmael Garcia, not somebody else. We have not had one piece of evidence that's been presented that there was any sort of brokering deals that were going on for Ishmael Garcia. That is conjecture. We have not heard any evidence on that right now. Kevin LaBelle testified that when he saw both guns and he saw the defendant holding them, bringing them down from the attic at the Guilford Street residence, the place where he said he hid them in the walls and in the ceiling, the same place where Tara Hilbert told you he later bragged that he had an AR-15 and that he hid it in the walls. Plus, as he stated before, the fear that he had that the ATF was looking after him as a result of that possession. Both Mark Reed and Kevin LaBelle testified in cross-examination and were confident in the defendant's actions about possessing the firearms with the intent to sell the guns at the time. That's hands-on, that's possession, that's disposing of the guns, that's selling the guns, and the reason for selling the guns was for the benefit of himself, not for Ishmael Garcia. And again, both of those men's statements are corroborated. The video that we just saw, and I know we talked about it just a moment ago, so I apologize for repeating myself, but that's a video that shows, again, the defendant is trying to distance himself from the evidence of the crime. He's having not himself go to the Eco ATM and put his own license and have himself deposit that phone, which he had logged into his account and sent the messages to Mark Reed, but he has Kelsey Small do it, his girlfriend, assisted by Caleb Montgomery, who then, as the transaction is completed, he leaves from that area, making sure he's certainly not on the video that was snapped by Eco ATM. And his identity is clearly established through the rest of the footage Sullivan corroborates the testimony as well, having seen the defendant with both a shotgun and a rifle, most notably for that rifle transaction in exchange for the gun next to his house. And Adam's statements later on to him that if Kim had had cameras, then he would have been arrested. All of that evidence, Your Honor, taken in the light most favorable to the state, shows all three sets of the charges, the baseline of armed career criminal for the possession, certainly with a purpose to deprive thereof of being firearms, and then beyond that, receiving stolen property and the theft all came from this defendant. And the state feels very strongly that the matter should go to the jury because with the defendant's statements alone, or when you then start adding in the corroboration of just a handful of witnesses, and then you add in the corroboration of all of the witnesses that have testified, the state has shown that it will be able to meet its burden moving forward.
Okay.
So we'd ask you at this time to please.
He's wrapping up. There we go.
All right. To succeed on a sufficiency of the evidence claim, the defendant must show that viewing the evidence in the light most favorable to the state, no rational trier of fact could find guilt beyond a reasonable doubt. The state has set forth much of the evidence that's been presented. The court does not find that the
Denied.
defendant's motion is a viable one or that it should be granted. There, as noted by the defense, credibility issues are for the jury to decide, but there is ample evidence here that the defendant both possessed and had control of these firearms. As noted by the state, there was statements by Kevin LaBelle, Michael Sullivan, Mark Reed, all of whom communicated with the defendant around the firearms. Kevin LaBelle testified that he saw both of the firearms. Mark Reed also testified that there was communication about the sale of the firearms with the defendant. Kayla Montgomery testified that she saw the firearms in the house. Chris and Kim Frayne set the stage as to when those firearms were removed from the house. Based upon all of the evidence that's been presented at trial, the defendant's motion to dismiss is denied.
Denied.
All right.
My witnesses are all ready.
Okay.
Oh, she has witnesses. They're all ready. And we're going to be done before
Approach for
lunch.
just a minute.
Okay, so here's what we're doing. Let me tell you, it's going to be a busy day. We have, let me show you just a quick little check. We have on standby, we have this little court, this little goodie, Judge Cedric, where we're expected to see Cynthia and James. We watched them. The modern day Bonnie and Clyde. I would say an experienced, age-wise, seasoned couple who are accused of sort of tag teaming and doing some shoplifting at Walmart. Cutest couple in the world, have no idea, no criminal record that we know of at all. We are on Team Cynthia and James. The judge also realizes that these two were just, they made a poor decision, but we're going to see. He tried to convince them to take a lawyer, to get a lawyer, a court-appointed lawyer. They didn't want to spend the money. They were just going to face the charges themselves.
We're going to take a 10-minute break.
And so we're waiting for them. We're going to watch that. If that happens, we're going to pause whatever we're watching. We're going to pause it, and we're going to jump over there because I have to take that one live. I will record it as well, so I'll have a copy, but I can't record it unless I'm taking it live, and I can't get the audio unless we're just watching that. So we'll do that. So we have Cynthia and James at any moment. We can interrupt and handle Cynthia and James' issue in court. I'd love to see how the judge handles that. We want to get closure on that one as well. When we saw them the first time, they're just awesome. They're side by side next to each other. They're like, "Yep, we just want to." Do our time, we're going to handle it on our own. He's like, no, you don't want this. You want a lawyer. You need a lawyer. The judge was great. So we're going to follow that and see how that goes. We're expecting them to be on today. Also, the new trial we're following starts today. So during the breaks, when it's not Cynthia and James, or after during deliberations, we're going to start picking up the new trial, which is the Scott Peterson trial. This is at the the school resource officer who was at the Parkland school, who should have, or the state is arguing that he should have gone in and done something to help stop that or help the kids. And he stayed outside. He didn't. This is a very unique trial. Obviously, it's got some political issues around it. We're going to try to skirt those issues a little bit. As you know, we do pickles, not politics here. But we are going to we're going to try to watch that trial. It's a long trial, so we may not stick with it every single day. Obviously, they have breaks. They have like a week-long break halfway through, a couple days into the trial. So it's going to be hit and miss, but we're going to follow that one through. And I really want to see the outcome of that trial. So that being said, it needs to have good audio too. If it's terrible, we might have to do something else. But they're not real criminals. If shoplifting from Walmart, I want to know what it was they were taking. I want to know how much there was, everything like that. We'll keep an eye out. If anyone sees Cynthia and James as you're watching Cedric's courtroom, Honorable Cedric Simpson's courtroom, please let the mods know so they can trigger the buffer sound, because I need to take that just as soon as it happens. I'll start doing an ISO record, get the audio running and everything. Let's see. Yes, it's on Law and Crime Now. We realize that. We're going to follow this one until we get a verdict, or at least go into verdict watch. Then we're going to pick up sorry, I'll get this to you in a second, Mary. Then we're going to pick up the Scott Peterson opening statements, and we will catch up. We'll play that a little bit faster. We'll catch up with that one. We expect to be caught up with that by tomorrow. Depends on how long deliberations go in this trial. But yeah, so some days we have very little to go over. Today we have a lot to handle, and a lot. So it's going to be great. People are starting to come online on Cedric, so keep an eye on that one. Mary C., I want a mug that says Recover Addict, but never see it in your merch. Let me, here's my problem, Mary C. I only have one graphic, and it's awesome. It was made by Stephen Lee. It's this one right here. That's my graphic. That's all I've got. I can put that on a mug if you want. I'm not very good at graphic arts. I need some help designing some. I know a couple people have reached out to me saying I'd like to design some stuff for you, and I'm waiting to see some designs from them. But let me know. Let me know if you want that picture or just my name or something else. I'm not sure how to do that. I need some help. Why hasn't Ish testified? We don't know. We don't know why Ish didn't testify. It looks like Lee and Shells are striking up a conversation there in the courtroom. They're getting all the scoop. All right, have fun. Love you. Drive safe. Enjoy the new car. Okay. The family's going to the water park because it's Wet Wednesday is one of our little holiday things.
SBLF.
Sarah Boone Letter Fund has another donation from TW. TW, thank you very much. We're just on a quick break. We're about to turn it over to defense. Defense does have some witnesses. So we're going to pick up the Scott Peterson trial in a little bit. We expect to have the opening statements this afternoon because this trial is going to be quick. Or at least the remainder of this trial is going to be fast. There are 3 Scott Petersons with high-profile cases. Apparently, that is like the most common name for any felon is Scott Peterson. So if that is your name, just know we've got our eye on you. We're watching you. Be sure to add RA's huge bug to the graphic. No bugs in the graphic. We can't do that, Stephanie. I know which bug you're talking about. Walmart's absolutely voracious when it comes to prosecuting shoplifting. I forgot to pay for a $5 pair of baby shoes, and it wasn't even out the store. Was about to head to self-checkout to pay, and they jump all over you. Man, they just anticipate theft. We need the one Steven did for police chases with cones flying on a mug, too. That's a good one. I'll look for that one. I've got that. Obviously, I've got the original, but let me see where that's at. Can you let Brandy know she's muted right now? Yeah, I'll text her. Somebody's already going to tell her she's muted. There's no way that she's gone this long. Her chat's going to let her know. Okay, I texted her. Did defense call any witnesses? They are going to call a couple. I'm dying to know who this guy Shells and Lee are talking to. Let me take a look in chat. Is it obviously they're not going to like interrupt the conversation to text about it, I don't think. We are Cynthia and James addicts. I'm watching right now. It looks like the judge is in the courtroom. In the Cynthia. I'm sorry, not that one. It's over here.
They're going to be seated immediately next to Mr. Lambert, and to not allow obvious.
Yeah. So we'll keep an eye on that. As soon as Cynthia and James show up, I'm going to start. We'll jump over there. That's something. It's worth pausing whatever we're doing in the Adam Montgomery trial, as frustrating as this is, to watch Cynthia and James. Okay. Oh, look at this. Lydia Phillip. Welcome to the gallery. Thank you so much for joining as a member. I appreciate that. You have all sorts of perks. One of them is you get to talk as much as you want in chat, even on slow mode. Another membership is perk is you get a courthouse by your name, as you just noticed. A blue courthouse that changes color as time goes on. Okay, I might be able to help Brandy really quickly. Hold tight. We're gonna hear her just briefly on the channel. She's having some audio issues. Okay, where is she live? There she is.
Given in this case, you must.
Okay, so. It's really loud, and they're giving jury instructions or something. So I'd have to wait till she talks to hear what's happening. She might be coming in just on one side or the other. Okay, where Cynthia and James live? Sorry, Caps. No, it's okay, Pi. We're thinking they're going to be in. Today was the date for them to show up in Honorable Cedric Simpson's courtroom, which is a virtual room broadcast on Zoom. It's going to be on Zoom, is my understanding. So we're going to keep an eye on that. RA, Miss RA is off chasing school buses in the new car, beating Scott to it. That new car is nice. We love it. The kids like it just because it has a DVD player. Our last car had a DVD player too, but we only had one DVD in the car. I don't know why. Just think this through. We only had one DVD in the car, and it was like Music Man or Mary Poppins or something like that. And the kids would watch it over and over and over. It doesn't matter where we're going. They'd watch Mary Poppins. They'd watch that video. And the disc was all scratched up because it had been like under the car seats, been kicked around for a while. And so half the disc didn't work. And they'd watch that over and over. And so we got the new car, and they're like, oh, let's go get the disc. I'm like, you realize we have a whole case full of DVDs, like 500 DVDs in there. I'm like, oh, the light comes on. For some reason, they thought that was the only movie they could watch in a car. But now they're watching all sorts of classics. Okay, lots of activity on Judge Simpson, but nothing interesting yet. Okay. Gave jury instructions for an hour yesterday that were boring. Let's see if there's any more. Sorry, he's still rambling. Yeah, so we're going to be watching Judge Cedric's YouTube channel. I'll bring that to you live as soon as that happens. I've got it in one of my screens, so you can see here. Right here, this screen right there, that's Judge Cedric's room. I can show a big screen like that. That's what it looks like. So I'm keeping an eye on that one. As soon as we see Cynthia and James pop on here, we'll take care of that. But meanwhile, we're back here in this court. We've got a little break, as we're about to have defense testimony. They have a couple of witnesses. They should be done before lunch, according to the judge. You remember they had a sidebar, and the judge said, you might have this before lunch. So the jury's ordering their lunch right now. They anticipate being in deliberation already. Can you explain who's the Cynthia and James thing? I don't know who they are. Riley. Oh my goodness. We might need somebody to go back and find whatever live stream we were doing. It was court hopping, but I don't remember the day we did this. there was we were jumping from one courtroom to another around, the Zoom courtrooms, the ones that are televised on Zoom and on YouTube. And we're following a couple different cases. We went to Florida for a lot of drug cases and things like that. And then we ended up in Judge Cedric's courtroom. And there was this older couple who were just the sweetest little things. We're like, what are they doing here? They're definitely not hardened criminals. They're just a nice couple. It turns out they're husband and wife accused of shoplifting, I believe at a Walmart. And they show up and they've never been in the system before, and so they're like, we're just here to take care of it, we're going to do it on our own because obviously money's tight, so we can't afford a lawyer. We're just going to do it ourselves. And then the judge took his time trying to say, can I at least appoint you a lawyer? And they're like, no, we don't want to do that. We'll just handle it on our own. He's like, no, you don't want to do that. You don't want to do that. And so he took so much time just explaining to them, finally saying, look, it doesn't cost you anything. It's completely free. The state will pay for this, or the county will pay. This lawyer will represent you. You can talk to them. He'll help you out. It won't cost you anything. And they're like, oh, in that case, we'll take the lawyer. And so he's like, oh, good. We assigned him a lawyer, and they're going to handle that case. And today we believe they're going to be back in front of the judge after they've talked with the lawyer. Now realize the judge, he's already got a soft spot in his heart for these two. They're not hardened criminals. Yes, they did something wrong. I don't see him throwing the book at them. I just don't know how it's going to go. I do anticipate, honestly, they're going to plead guilty because they did it. And they know they did it, and they're like, we're just here to take care of it. We made a mistake, and we want to make it right. But that's my anticipation. It's like they're like my grandparents. I love them. They're amazing. Okay, what kind of cars? I bought a Yukon XL, a white Yukon XL. May 17th, speed dating. Adam, thank you very much. That was the date we found Cynthia and why did I just lose Cynthia's name? Or Cynthia's husband's name? James and Cynthia. Not on the stand today? Ish. We can go ahead and pin this one. Thank you, Greeners, for that. Ish did not testify yet. He may still testify for the defense. They brought him up several times. So maybe he'll be there for that. Yes, we're doing a little multitasking today, Lindsay, but we're keeping an eye on that. I realize the Scott Peterson trial is beginning. It's going to be a tough trial, but at the same time, it's covering. You know me. I like to see trials that have new elements. We love the murder trials. I'll always love murder trials, and we'll always be following those. It's hard to fill ones that involve children. This one does, but it's not directly. This is not to the shooter that's being prosecuted. This is somebody who could have stopped the shooter and was in a position and a location where he had opportunity and he didn't. And so he's being prosecuted for not doing that, because police officers pretty much nationwide, when they take their oath, they're sworn to protect and to serve.
These are the revised instructions for you. I noticed there's a formatting issue on.
James and Lee, you are the stars. You're the stars. You're amazing. Thank you so much. Or James and Shell. Sorry, James and Lee. I'm mixing up Cynthia and James and Lee and Shells. Obviously, my mind's. I'm doing too much multitasking right now. There are a few people there in court. A few more than normal. Weebug, did you see your text in the burner yesterday or Monday? I think so. Did I not reply? Hang on one second. I want to see if I can hear Brandy. Just one moment. Okay. I can hear her a little bit.
All right, do y'all want to do before lunch?
Yeah, so I can hear Brandy just fine.
All right.
I was just trying to help her out a little bit. Weebug, let me know.
Jury, please.
Text me again, and I'll look at the. We'll put your text at the top. Yeah, we're going to be catching up on the openings later, so we're going to be a little bit behind. We'll watch them a little bit faster than normal speed, which I don't think will hurt us. But 1.25 speed, we'll catch up with those. Hopefully we'll be caught up by tonight, and then we'll be ready with the case tomorrow.
For jury?
Carol, you've got a green courthouse. That's color number 3. That's color number 3. It starts out dark blue, and then it goes teal, and now you're a light green. So that's the third color. It looks like it's working on my end. Yay! Yes, that's awesome.
Please be seated. Attorney Smith, does the defense wish to call any witnesses?
Yes, Your Honor, we'll call First Officer Ranini.
Officer Ranini. Is he a canine handler? Let's hear her swear him in.
If you could raise your right hand, do you solemnly swear the testimony you're about to give is the truth under pain and penalty of perjury?
Yes, ma'am.
Please have a seat.
He doubles as Mr. Clean.
And
Stunt
could you
doubles.
state your name and spell it for the recorder?
It's Kenneth Brunini, B-R-U-N-I-N-I.
That's not too hard.
Sort of apparent by what you're wearing, but could you tell us what you do for a living?
I'm a Manchester police officer.
How long have you been a Manchester police officer?
Almost 16 years.
I expect him to say all
And
my
what
life.
is your position within the department?
Currently, I'm a sergeant in the patrol division.
And what are the duties of a sergeant in the patrol division?
To supervise the police officers, to enforce the rules and regulations of the state of New Hampshire, and investigate crime.
Okay. I'm going to turn your attention to October 3rd of 2019. Did you respond to the Franz home at 252 Russell Street?
Yes, ma'am.
Do you recall what time you responded there?
I'd have to look at my report. I don't remember off the top of my head the time.
So if I showed you a copy of your report, would that help refresh your recollection?
Yes, ma'am.
Is this a copy of your report?
It is.
And does that refresh your recollection about what time you arrived?
It does, almost 9:45 in the morning.
Okay. And in the morning, you did
Yes,
say? 9:45 in the morning. While you were there, and I have to limit some of the questions that I'm asking of you, okay? Did you receive a list of items claimed to have been stolen?
Yes, I did.
And who did you receive that list from?
Christopher.
And do you recall what the items were on the list?
Yes, I do.
What were they?
It was one pistol, one rifle, one shotgun, a wedding ring, a watch, and then subwoofer speakers.
Okay. Was Kimberly Fran, did she come to the house while you were there?
I believe so, yes.
And did you speak with Miss Fran about the missing items that were on that list?
Yes, ma'am, I did.
And did she tell you, what did she tell you about whether she was aware or not of any of the items being stolen?
She told me she was not aware of the items being stolen.
Okay. Did she explain to you what happened to any of the items?
No.
Okay. So did you ask her about the items on the list?
I asked her, yes, I asked her what had happened.
And did she tell you whether or not she was
Sustained.
May we approach?
Yes.
Now she doesn't like it. The objection to hearsay comes back and bites her. She's like, but I need this evidence. Well, that's how it works. That's a double-edged sword, that hearsay rule. Sometimes it cuts you and sometimes it cuts them. Learning lots of accents. This is a great accent. Love it. Yeah, obviously a police officer being called as a defense witness interesting scenario. He's basically just going to tell the truth. That's the general premise of what people do on the stand. But how they spin that truth, or how they focus those questions might make the defendant look good. Particularly, it sounds like they're focusing on the information they had that Chris Frayne, initially filed a report saying lots of things were stolen that we learned were actually just pawned by either the defendant or the defendant's significant other, Kim.
That understanding, Your Honor, objection withdrawn.
Objection withdrawn.
So when you spoke to Ms. Fran about the items on the list, and I think I asked you what she said and you answered, and then I asked if you asked her again. So that's what I'm focusing on. The second time you addressed the items on the list, right?
Okay.
I've confused you.
I'm confused. Yeah, sorry.
Okay. So I'm trying to go to something very, very specific. One of the items on the list was the ring, right?
Okay. Yes, it was.
Okay. And did she tell you that she had nothing to do with the disappearance of the ring, one of the items on the list?
I don't recall that specifically.
Go ahead.
I believe when I was speaking to her, it was in regards to all of the items.
Okay.
Nothing specific individual.
So you talked about each of the items, and she said that she didn't have anything to do with those items' disappearance.
Correct.
Thank you.
Ladies and gentlemen, that question and that answer involve a prior inconsistent statement. When I give my instructions to you, I will give you an instruction about prior inconsistent statements. But what I will tell you is you cannot consider the prior statement for its truth. The prior statement is to be considered by you in determining, in using it to determine whether or not to believe a witness. Okay, so it's not, a prior statement in this context is not to be used to determine whether or not that particular statement is true, but rather it can be used by you in determining whether and to what extent you believe a witness. So it's for the purposes of credibility.
So they're impeaching Kim.
No, I'm sorry. Okay.
Your Honor, you don't mind me asking from the table?
No, that's fine.
Officer Bernini, can you hear me all right?
Yes, sir.
All right. If for some reason you can't hear me, please let me know, and I'll be happy to speak up.
Yes, sir.
I just have two quick questions for you. When you spoke with Kimberly Frayne, in speaking with her, did you make her any offers or promises in exchange for her sharing this information with you?
No.
And also, did you do a check for security cameras around the house?
I did.
In fact, you found there were no security cameras at that house or around that house. Is that right?
Correct.
Thank you. I have no further questions for you. Thank you very much.
Thank you.
Okay, so his testimony, I think
You
they're done
said
here.
that you made no
Offers or promises.
promises or offers to Ms. Fran, right?
Correct.
You actually had no agenda walking in other than to investigate that case.
Correct.
Thank you.
Thank you.
All right. You may step down.
Thank you.
Okay, so all that did was
I'd like to call Officer Slocum.
Oh, Slocum's coming back up. This is a repeat witness.
May I be excused?
Yes, he may be excused.
So all that did was impeach Kimberly Frayne, where this officer said that she didn't say anything about the ring, and she said that she did, or something like that. And so now it's his testimony versus her testimony.
Would you raise your right hand? You solemnly swear the testimony you're about to give is the truth under pain and penalty of perjury.
I do.
Have a seat, please. Could you state your name?
My name is Eric Slocum.
And could you spell both names?
Eric is spelled E-R-I-K. Slocum is S-L-O-C-U-M.
And
We saw him before, right?
what do you do for a living?
I work as a police officer for the state of Manchester.
What is your position there?
I'm a patrolman on the midnight shift.
And
Guess
how
we didn't
long
see
have
him.
you been with
did.
the Manchester Police Department?
7 years now.
And what are your duties as a patrolman?
As a patrolman, I respond to calls for service, investigate crime, arrest offenders, and deal with other kind of quality of life issues that might arise.
And were you in the street crime unit for a bit?
I was assigned temporarily on an overtime basis for about maybe 1 year with the Substance Abuse Reduction Group, where I got to work alongside detectives within our Special Enforcement Division, which is our narcotics unit.
And what you said about a year, what year was that?
2019.
I'm going to turn your attention to 2019. Did you, specifically December 19, 2019, did you have contact with a Kimberly Frayne?
Yes, I did, while on midnight shift patrol.
And what was the nature of that contact?
About half an hour after midnight, I responded to the Shell station on Hanover Street as the clerk there had called 911 saying a female was passed out in a vehicle.
And did you investigate the female passed out in the vehicle?
Yes, I did.
And did you subsequently arrest her?
I did.
And what were the charges?
Just one count of possession of crack cocaine.
Okay. And it was possession as in it was on her person at the time that you arrested her?
At the time I arrested her, it was directly where she was sitting in the driver's seat.
Okay. Now, did you subsequently speak to Ms. Frayne?
Yes, she was transported to the station via the wagon, and then in booking I processed her, which was doing fingerprints, photos, and basic search.
Did you end up talking to her about a prior investigation into missing guns from her home?
Yes, I did.
And did she give you some statements about what she knew about how those guns came to be missing?
Yes, she did.
And at that time, what did she say about how those guns came to be missing?
Sure. We just have it tailored the same balance that we had before.
May we approach?
Yes.
Okay. There's an objection. I couldn't tell exactly something about what we've said before. Couldn't tell what it was. But the defense is trying to cast some doubt into the story of some of the witnesses. If they can make the witnesses seem uncredible or incredible, not like incredible like awesome, but lacking credibility, you'll give the jury, a pause to think, and might be room to say there's reasonable doubt. So they're doing a great job there so far. Let's see how this one gets ruled on. Lots of approaching. Yeah, I'm skipping over chat here. Cachette, the audio must not be working on your end. We'll have to get that fixed. I joke. I don't think we're going to get Ish. I think we're just going to have a couple witnesses, and that'll be it. Okay, I'm still watching Judge Cedric. I think we're still good there. Nothing yet. It might not be this session. It might be a later session. So we're down to 3 people in Cedric's court. I told you Ish wasn't real. He's the boogeyman. Nobody knows.
To the extent the objection is not withdrawn, it is overruled.
I'm going to ask you some questions about specific statements Ms. Frayne made to you about those missing guns. Did she give you a name of someone involved with the gun?
Yes, she stated Adam Montgomery was involved.
And did she say anything about when she I'm just trying to phrase the question right. What did she say about Adam being at her house?
She said that Adam was at her house the night when the firearms were taken.
Okay. And did she say anything about where, did she say anything about moving the guns that night?
She did.
What did she say?
She said she moved the firearms as Adam was staying on a couch at her residence that night.
Okay. And did she say what Adam was doing that night?
Adam was sleeping on a couch that night.
Okay. And did she say how long he was sleeping on the couch that night?
I don't believe she gave a specific time frame of when he was sleeping on the couch that night.
Did she say whether she saw Adam in the morning?
No, she left for work that morning and left Adam at the residence.
Did she say whether she said anything to Adam as she was leaving the residence in the morning on the way to work?
Yes, she told Adam to lock the door behind her.
Okay. So what she told you in December was the two of them were there. She had moved the guns. Adam and she went to sleep. And presumably Adam is still there in the morning because she told him to lock the door as she left.
Yes.
And she claimed that she was going to work, and that's why she told Adam to lock the door as she left.
Yes.
Thank you.
We're flying through these witnesses. We're about to have the defense rest here soon.
Ladies and gentlemen of the jury, as I said to you earlier, a prior inconsistent statement in this context is to be used by you only in determining the credibility of the witness, not for the truth of the statement itself.
Thank you.
They're impeaching Kim.
Officer Slocum, I have just a couple of quick questions for you. When you first interacted with her, you responded to that 911 call, and that was a call because somebody had reported that an individual was passed out in a car, sleeping in a car. Is that right?
Yes, sir.
So when you're responding to a call about that, one of your initial concerns is always the health and safety of the individual. Is that correct?
Absolutely.
And when you spoke with Kim Frame that night, in fact, I think your report documents, you noted that she was drowsy. Right?
Yes, sir.
You noted that she was lethargic.
Yes, sir.
You noted that she told you she was sleeping.
That's correct.
And before she said that, even when you first saw her, you saw that she was sleeping, right?
Correct.
No further questions, Your Honor. Thank you, Mr. Slocum.
Nothing further. You may step down.
Thank you.
Any objection to this witness being excused?
No, Your Honor.
All right, you may be excused.
Thank you.
Any more witnesses? They're only going after Kimberly so far.
All right, ladies and gentlemen, the defense has now rested.
They rested.
So it
That
is
was
time for closing arguments.
Here we go. Wow.
Proceed
Wow,
whenever,
wow. Defense rests.
whenever you're ready.
Now in this one, let's try to remember, New Hampshire does it differently, right? Defense goes first, and then prosecution, one shot each. And here she goes, she's moving the furniture.
Good morning, ladies and gentlemen. When you rely on a lie, you reach the wrong conclusion. Kim Frame lied. She lied about the missing guns. She lied about the .45 being in her car. She lied when she was asked about bartering guns for money. She lied, too, about the long guns and moving them. She lied to protect herself and Ish. The state's case relies on lie after lie after lie. And the police in this case reached the wrong conclusion. Adam Montgomery did not steal the firearms from the Frames' residence. He did not possess or control those firearms that were missing, nor did he possess, maintain, or dispose of those firearms. Chris Frayne told you that on Sunday, September 28th, all 4 of the firearms were in his bedroom. He told you that the 2 were under the bed wrapped in blankets, AR-15, and the 12-gauge shotgun. 2 in his dresser drawer, the .45 and the .380, both handguns. He then left for his business trip to New York, and he told you that generally he leaves on Sunday nights and returns on Fridays. But this time he told you he returned on October 2nd. That was a Wednesday. That was early. Kim Frayne only learned that Chris was returning when he called her from the road, and Kim panicked. While Chris was away, she had been using drugs heavily. So heavily that she had gone through all of her money, but she was sick and still needed more drugs. You heard from Mike Sullivan what dope sick feels like. You're sweating, you're sick, you don't have control of your bowels, and your whole body is in pain. Kim called Adam to see if he had any drugs, but Adam was out as well. Adam drove to Kim's house and they both made calls to see if they could get drugs. Kim called Ish. Kim told you that Ish was one of her dealers and that Ish would drop guns off at her house. During her testimony, she told Attorney Smith, but she wouldn't call Ish if she didn't have money. When pressed on it, she agreed that if she didn't have money, she would barter. She and Ish had bartered for drugs before. She had allowed Ish to use her car in exchange for drugs, and she had allowed Ish to use the .380 in exchange for drugs. And we know that Kim got her drugs when she was sick. And we know that because when Chris came home, he never mentions that Kim is sick. And when Mike says she came over to the house the next morning, he never mentions that Kim was sick. Kim knew that she could barter for the drugs, and she did. Not only the .380, but for Chris's prized possessions. Not for sale, but to be used while Chris was away, like she had done before. So when Kim received that call from Chris that he was headed home, she freaked out because Ish still had the guns. Chris told you when he got home, he checked on those guns because he was going to the shooting range and he didn't trust him.
I've got a
You
little
heard him testify that before
limerick
this,
for you.
he had noticed that money was missing and other small items. He also said that he knew Kim was using. And when he checked the guns, 3 of them were gone. But curiously, the .45 remained in the dresser drawer. The gun that Kim liked, the gun that she told you she had carried, the gun that was in the same drawer as the .380. But the .380 was missing. And the gun that was of the highest value, Chris told us that the .45 was worth about $1,000. Chris immediately became suspicious of Kim. And Chris was pissed. Kim told you that he tore the house apart looking for the guns. And he asked Kim repeatedly where they were. She denied knowing anything and kept repeating they must have been stolen. But Chris wasn't buying that story. Chris had a dog that barked when anyone came into the house. He did not believe that there was any way someone came into the house unnoticed. He also didn't believe that no thief would have taken one gun out of the dresser drawer and left the other behind. Kim knew more than she was saying, and Chris told Kim that if the guns weren't back, he was calling the police. That meant trouble for Kim. The next morning, Kim went to Mike Sullivan's house. Mike could help her get the guns back. She told Mike that Ish had stolen the guns from her house. Mike contacted Ish, but Ish told Mike the guns were not stolen, that Kim had exchanged them for drugs.
That's not testimony.
When Kim was at Mike's house, Chris Frayne called the cops. And Chris called Kim while she was still at Mike's house to come back and talk with the cops. That's when Mike Sullivan knew that the police had been called. And he let Ish and Manny know the police had been called. At that time, Ish had to get rid of the guns. You heard from Mark Reed that it's pretty commonplace for users and dealers to be able to flip guns.
Looks like 11 o'clock.
He told you that he had done it for money. You get a cheap gun and then you flip it and get money for drugs. Ish contacted Adam to help him get rid of the guns fast. Having the cops around put everyone in danger. In danger of getting arrested for using, selling, or whatever else people do when they are getting high.
Mostly just using and selling.
Adam didn't need the guns to possess them or move them. Adam did not need the guns to move them. He had photos of the merchandise. You heard Mark Reed tell you he saw the photos. Adam started making calls as soon as possible. The sooner they moved the guns, the better. He called people. You heard Mark Reed said Adam contacted him about the guns. You also heard that while they were negotiating, the guns were gone. Another deal had been made. Adam messaged him too late. The guns were gone, and everyone's problems were solved. In 2019, the police do no further investigation into the missing guns. Even though you heard from Detective Bergeron Rosa that on October 22nd of 2019, about 2 weeks later, the AR-15 was recovered at John Sargent's house. After they were surveilling the residence, the SWAT team had gone in, anticipating that there were weapons and drugs. And they told you that John Sargent had been convicted of arms trafficking. John Sargent had the AR-15, other guns, a crossbow, and brass knuckles. But even after recovering this AR-15 that belonged to Chris Frayne, there was no further investigation into the missing guns. The idea that the guns were around for weeks is not reasonable. The guns had to be gone fast, and they were, the same day. Too late. They were not found on Halloween being sold to two white guys. And they were not in the trunk of Adam's car. You also heard that in 2019, Kim was arrested. So just testified to that. And they spoke to Kim about the guns, and at that time she gave the police another story. This one was about Adam being at the house, her moving the guns behind the couch to be closer to her daughter, her leaving for work in the morning, and telling Adam to lock up. She mentioned that Adam was there that night. She hadn't mentioned that before. But the police did no further investigation. You heard that Mike Sullivan was arrested in November 2019 for drugs. You heard that the Manchester Police Department took him into custody and began telling him that they were going to take his kids. Mike told you they told him your kids are gone. Mike doesn't want to lose his kids, and he tells the police what he knows. He talks about the Frains missing firearms. He says Ish and Manny took the guns, and he mentions Adam. But in 2019, the police do no further investigation into these missing guns. The police do nothing about the missing guns until Adam Montgomery is arrested in 2022. And that's why you're here today. Because in 2022, the Manchester police were involved in a separate investigation. In 2022, the Manchester police wanted information about Adam Montgomery. In 2022, the police wanted Adam arrested and incarcerated.
Okay, we have audio
and
turned
the
on.
police begin to build their case.
We're going to stop
to
this
that
closing
end.
statement and take the
And
James
how
and
do they do
Cynthia's
this? They
hearing
look
live
back
as soon as it
at the
starts.
people Adam was around in 2019. They look at the people who had had police contact with them. And they began contacting people in Adam's circle. They start with Kim Frame. And Kim tells them another story. Adam came over, she fell asleep, she woke up, Adam was gone, the guns were gone, but there was a crack pipe on the table. She doesn't tell them about Ish or Manny, and she doesn't tell them about bartering for guns. She continues to protect herself and her dealer. I'll remind you that when I spoke to Chris Frayne about Ish, he agreed that he was scared of Ish and did not want to have any interactions with him. He too failed to tell the police about Ish until they asked him. And it was only then that he told them that Adam had told him Ish and Manny had taken the guns. The police go back and talk to Mike Sullivan again. In March of 2022, the police are actually looking for Mike because he didn't appear in court. He told you that he was supposed to go to rehab, but left court and continued to do drugs. You heard about the police raiding the house he was in Manchester, and you heard his description of that, Mike describing G.I. Joe style.
Okay, we're going to pause that one right there. We're going to switch right now because this is going to be great. We are going to pick up on this. We're not going to miss anything. We're going to catch up on the closing statements on this case. But this couple has captivated the nation and mostly our hearts. James and Cynthia, who are center. Let's see, where are they at? They're right here. Let's go right there. They're there. They're in the center right here. James and Cynthia, the cutest couple ever to be charged with, I believe, shoplifting. Husband and wife team. This is live. Judge Cedric's courtroom. We have to watch this live, so bear with us. A little background. We're going to go back and pick up exactly where we left off with the closing statement. So don't worry. This is going to be worth it. This couple's amazing. They wanted to just handle it themselves. They're the nicest people. I think there's no criminal record whatsoever. But the Judge Cedric, rightfully and kindly. Convince them. Cynthia's getting her hair done. She looks great. Cynthia, you look wonderful. Looks amazing. Convince them to at least talk to a free attorney, to have an appointed attorney. Actually, they have to have two different attorneys because I think their cases are separate. So I think they each have their own attorney. But they're here as a husband and wife facing the consequences of their poor decision, which I believe involves shoplifting at a Walmart. And this is where we're at. This is where we're picking up. Now, I don't know if their case is going to be first. Free Cynthia and James, says Riley. I don't know what they stole. We haven't got that far. We just heard the charges. There was like the initial appearance is all we had. But now they've had time to talk to a lawyer. And they got some great advice, I'm sure. Hopefully they're going to take it. Oh, look at this. Who's the shirtless guy who's showing up in the video next to them? not sure if he knows he's in court and on the live stream. But I don't know, Julie. I hope some of these questions get answered. Obviously, it would break my heart to hear that that they were stealing necessities. That say if it was something, if it was food, if it was something that was medicine, things like that. Where it's I'm hopeful they just made a poor decision. But if it's more than that, I'd want to raise some money for them. Honestly, I would. They're amazing. But James is in disguise. He has the hat on. I hope the judge doesn't take issue with that. Oh, hat goes off. Sorry, James's hat is off. Simpson will make him put a shirt on. I think that was somebody who was not a part of this trial. Okay, so we've got a few people here. No audio quite yet from the courtroom. Let me make sure everything's running right on my end. Yeah, we're all good. We should have audio as soon as it starts. This is his 11 o'clock docket, which should be any moment now. Do we know the location of James and Cynthia? Only that it's in Honorable Judge Cedric's court, and we've got their name, James and Cynthia Pearson. So I imagine with a little bit of sleuthing, obviously we would not want to put their information out on the web. So if you have their information, contact information, that's something you could text me directly, but don't put it in chat or super chat or anything like that. We're not trying to dox anyone, but depending on how this goes, I would be open to trying to help them a little bit. Let's see. Samuel is overdressed. What is that? What is he holding? Oh, he's got his arms like in a cast of some sort, which he has featured prominently. He wants it known that he is not in tip-top shape. I'm just so happy to see Cynthia and James again. This is so good. I hope. Obviously, I'm not condoning crime at all. I'm not condoning any crime, but I hope the judge looks at this and looks at the fact that as far as we know, there's a clean record. This is Michigan, Washtenaw, not Washika, Washtenaw County in Michigan. Thank you, Amy, for that. I'm not condoning crime, but I don't think locking up James and Cynthia would serve the public any good. These two, I believe, just from what I can see, would be better out in public, making cookies and things for grandkids, which is where they belong, not behind bars. Go fund me for James and Cynthia. Basically, something like that. That's what I had in mind. Possible lawyer. Yes, the lawyer, because they have a lawyer, we may not hear directly from them. With representation, typically there's very little speaking on behalf of the client. But we might get a little more information here. This is going to be good. A puppeteer injury, possibly. Yeah, the dude in the bottom, Samuel, who's I'm almost covering. He really wants it known that his hand is hurting right now. And he's got his mug. At least he can still drink with that hand. In the tank top,
Sorry,
which
I'm getting knowledge. You are funny. Two-Face with tears of joy. TKS.
Lilac Beach, thank you so much. This will be good. We'll get back to the closing here shortly, but hold tight. This is going to be good. Let me see. Let me make sure I'm over here. Okay. Not one of my mugs must be criminal. Yes. Okay, Saeed Akhtar. That's the one next to it says Cynthia. They were the ones that had the shirtless guy in the background. And there's also got the dude in the back. I'm not sure what he's doing, just standing up way back in the back. The candy cane hand. It's like, where's Waldo? Where's my hand? Type thing. There it is. Yeah, if it was a necessity, Momo Shark.
One of them coming on though, baby. Not for sure. When my first supposed to show, last time I was showed.
I'm going to see if I can get this a little smaller. in the corner
How
here.
to go to the thing?
Go to the, cause
Be way
this
down
was the
here.
number, right?
Yeah.
The 606. And this was your number ID number, and this was your password.
Yeah, but when I tried to do it, I tried to get on, nothing happened this morning. But I heard them, but I ain't hear nothing else.
Well, we can hear you.
But did you call that
Yeah,
number?
I called the number, but he posed, they sometimes, they supposed to send you a thing saying, but they ain't send me nothing.
Okay, so somebody's having some technical difficulties. We'll get this sorted out. They don't know that they're live, completely live. I think it might be Keith Malone saying he couldn't hear anything. I think Mahoney, he's an officer of the court, right? I've seen him before.
You gotta do
Michelle, we may need your services depending on how this goes with
overnight or this morning?
James and Cynthia.
Diarrhea.
Okay, judge is a little bit late. Seriously. This is like Zoom meetings when they first became a thing. So many people, I think, are using Zoom for the first time going to court here now. Heather, this is a small trial. The two people middle far right of your screen, James and Cynthia Pearson, is who we're here for. This is Judge Honorable J. Cedric Simpson, his courtroom that we're up here in Michigan. We're watching. They've been accused of shoplifting, and they wanted to just handle it in court on their own, basically plead guilty. Judge convinced them to talk to a lawyer instead. They pushed it out a little bit, so now we're expecting this to happen today. I don't know where in the docket in the 11 o'clock hour they're going to fall, but we're going to follow this, and then we'll jump back to get the rest of the closing statements from the Adam Montgomery trial. Don't confess, Keith. Yeah. One of the participants has their mic unmuted. That's why we're hearing those little sounds. Oh, look, Francis Mahoney up there, top middle. He's also got a glove on one hand. Maybe he's trying to show off that he too can have a hand prominently in the picture. A fingerless glove. And he's like cracking his knuckles. I think this guy means business. Must be a prosecutor. You could go in person too. This judge is amazing. If you've never seen Judge Cedric Simpson,
They don't sound as weepy as yesterday.
he's just an incredible guy. Yes, I did hear the D word. Ruth Miller, welcome. This is a great day to join. James and Cynthia, we are here for them. We're pulling for them. We hope that their life of crime is behind them and they can make the changes necessary to become just upright, upstanding citizens for the rest of their time here on Earth. But we're hoping that everything works out well today. We'll get more information as well. Yes, someone's medical information was coming out, but we don't know whose it was, so we're not sure. Looks like Keith Malone is arranging his backdrop. There you go. Looks good. Picky, we're here for a hearing. We've interrupted the case we've been following for a week just for this hearing with James and Cynthia Pearson. I'm not sure if this is going to be the. I'm not sure what the hearing is actually called, which one they're doing here. But modern day Bonnie and Clyde shoplifting from Walmart, cutest couple ever, sitting side by side, ready to take on the justice system. Last time they were super early and sat through several cases before theirs were heard. I'm hoping the judge, I don't know, he might get some of the riffraff out of the way before he handles them. You guys are the best. Why on Zoom, not physically in court? Lisa, a lot of courts found out that it saved them a lot of money and a lot of time to be able to do Zoom hearings. It saves people the travel time, traveling down. Wow. That was a you are unmuted sound. I think the only people that could hear that are the people who are unmuted and us.
You are unmuted.
I'm not sure what's going on, but I think Terrence Moore and Keith Malone, they are the only ones that react to that. So I don't think James and Cynthia are having any trouble. That was the remix. We need to drop a beat here with the next one. Okay, judge is here. Okay, we're going to get the show on the road.
Okay, I'm live.
The 14A District Court is now back in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding. Mr. Interpreter, could you please raise your right hand to be sworn? Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Urdu and from Urdu into English in the manner now before the court, so help you God?
I do.
Thank you, sir.
All right. Good afternoon, Mr. Interpreter. Court does call the case. People of the State of Michigan versus Syed Akhtar. 2 cases.
बस जज साहब ने बोला था वो कोर्ट का आपको केस बुला रहे हैं आने के लिए.
Silvana Reed, Assistant Public Defender, on behalf of Mr. Akhtar.
Karma Dadush on behalf of the people.
वो अपनी वकील का नाम बता रही थी तो कौन किसकी वो किसी वकील किस चीज के लिए है.
Okay.
नाम बता रहे थे.
Heard?
So what are we doing today?
जज साहब ने पूछा क्या कर देंगे आज.
We are still waiting. I believe there is a competency report available.
इसने बोला था तो वो उसका वो यकीन है तो वो रिपोर्ट जो है ना वो है मौजूद है.
I unfortunately have not been able to get my hands on the report itself.
लेकिन वो इस वकील से वो रिपोर्ट को अभी तक नहीं मिला.
One of his cases in the 15th District Court was dismissed based on that report.
वो जो पिछले केस वो 15 कोर्ट जो नंबर 15 वाला था वो ने डिसमिस किया था इस रिपोर्ट के बारे में.
And the competency hearing in his felony matter has been adjourned to the 22nd of June.
और जो उसकी वो जो दूसरा जो केस है ना वो उसकी कॉम्पिटेंसी के लिए वो आगे की है तारीख. You said 22nd June?
Yes.
22 तारीख जून.
I would like to ask if we could adjourn this out to July so that we can see what is in the felony matter and if I am able to get a copy of that report.
वो पूछ रही तो वो हम इस कोर्ट का इस जो केस जो है ना हम अगले जुलाई तक हम आगे पुश कर सकते फिर वो जो उसको मौका मिलेगा रिपोर्ट पढ़ने के लिए और वो चेक कर सकती है दूसरे केस में क्या बन जाता है.
Additionally, I do have some requests regarding bond for some travel that the family is planning to do, and that is also why I will be asking for a later July date as they will be out of the country.
और वो भी ये भी कह रही थी तो वो उसके वो अपने लोगों ने सफर भी करनी है ना तो इस वजह से उसने आगे पुश करने के लिए जुलाई के लिए तो आप लोगों का मौका मिले ना अपनी वो वेकेशन जाने के लिए.
तुम खड़े हो यहाँ पे. Okay.
Any objection from the people?
Your Honor, no objection to the travel, but the people are not in receipt of this report that defense counsel has talked about.
वो पीपल जो कोर्ट वकील जो है ना वो कह रहे कोई मसला नहीं ऑब्जेक्शन कोई है नहीं इसमें ट्रैवल करने के लिए लेकिन वो इन लोगों को रिपोर्ट भी अभी तक नहीं मिला है.
Okay, what I will do is I will adjourn the proceedings to July 5th, 2023, 9 a.m.
Oh, we
Is
will.
it possible to get the 19th, just given their travel schedule?
वो पहला इसने जज ने बोला था मैं जुलाई 5 में करूंगा सुबह 9 बजे, लेकिन फिर दूसरे वकील ने बोला था तो हम अगले जुलाई 15 तारीख में हम कर सकते हैं, बिकॉज आप लोग तो सफर करेंगे ना उस दिनों में.
I'll adjourn it to July 19th, 2023, 9 a.m. With reference to the travel, you need to put that into a written order for my signature.
Okay.
By stipulation.
जज साहब ने बोला था तो वो अगले जुलाई 19 में वो तारीख बनाएगा केस के लिए, और जब आप लोग को जो सफर करने के लिए तो वकील साहब को लिखना चाहिए और जज साहब को देने के लिए अपनी दस्तक के लिए साइन करने के लिए इजाजत देने के लिए.
I like that Keith Malone is folding all his laundry here while he waits. He's not wasting time.
All right, thank you.
Have a good
one. Continued.
और वान अभी तक है.
Thank you, Mr. Interpreter.
Yes, Your Honor. Always a pleasure, sir.
Yes, sir. We have a problem here. It dropped. Folks, if you can hold on one moment. I'm just going to do it this way. See if I can.
Okay.
You see me?
I see you. Your video's off.
And not anymore. Okay, there we go. And I think we'll be good because I'm using a different band. Court does call the case of the People versus R.B. Gonzalez.
Karma Dadish on behalf of the people.
Good afternoon, or excuse me, good morning, Your Honor. Marcia Creature on behalf of Mr. Gonzalez. Mr. Gonzalez, can you please state your name?
R.B. Gonzalez.
Hey, what are we doing?
Your Honor, I'm requesting a 2-week adjournment. I was just retained on this, and also I just downloaded video of this incident this morning that I have not been able to share with my client. Thank you.
Video of the incident. He's
Got
guilty.
objection, June 21st, 2023, 9 a.m.
Thank you, Your Honor. You have an excellent morning.
All right, Bob, we'll continue.
Yeah, thank you.
Court calls the case, People versus Samuel Levine.
Karma Dadish on behalf of the people.
David Shan on behalf of Samuel Levine, who is appearing via Zoom. Ma'am, can you please unmute yourself and state your name for the record?
He's the hand guy.
Samuel Levine, appearing via Zoom. Good afternoon, Judge Simpson.
Good afternoon, sir. All right, what are we doing?
We do have a plea in this matter. Caitlin, do you want to put it on the record?
Yes, Your Honor. It's my understanding that Mr. Shand had tried to get in his client to Veterans Court. We got an email yesterday to the effect that he was denied from Veteran Court services. But with that being said, I did speak to Mr. Shand after that. It's my understanding that he is still receiving treatment and is still doing well with that treatment. He does not qualify for any other sobriety court in our county for the same reasons why he wouldn't apply, why he wouldn't go into Veterans Court. So given the fact that he's going to do this treatment on his own, and Mr. Shand is also going to ensure that he continues with this treatment as well as probation, the people would offer an added count 2, which is operating while visibly impaired second offense. The original count 1 would be dismissed with the agreement that he is to continue on that treatment path and to continue his sobriety.
That is correct, Your Honor.
Okay, and that's a 1 year.
Yes, Your Honor.
It's a 1 year offense, got it.
Your Honor, it was a classic military catch-22. He was discharged because of alcoholism, and therefore the VA cannot provide him with any services because he was discharged because of alcoholism, even though we were trying to get him to Veterans Court to treat his alcoholism.
Yeah. Okay, got it.
Got it?
Yeah, okay. Sir, can you please raise your right hand?
Other right.
Yes, sir.
There you go.
All right. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
Samuel Arthur Levine.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of operating while impaired, second offense. That is a misdemeanor punishable by up to, is it a $700 fine or is it $1,000? What is the maximum fine on this? I don't know why it's escaping me.
It's 200 to 1,000, Your Honor.
It's 200. It's the same, but okay, gotcha. All right. It's a misdemeanor punishable by up to 1 year in jail, a $200 to $1,000 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. The court could also order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. And if I didn't say so, your vehicle is subject to immobilization. You understand that, sir?
Yes, sir.
And understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You're also giving up your right to appeal of right. Do you understand that you're giving up all of those rights, sir?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, sir.
Anybody threaten you or coerce you?
No, sir.
Doing this voluntarily and of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
On July 25th, 2022, at the location of Crescendo Lane and Concerto Trail in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
And what'd you have and how much?
I had several beers and several shots of Fireball.
All right. Were you stopped by the police or was there an accident?
I ran over a little median in the middle of a subdivision. I kind of stopped myself. I flattened all four tires in the car.
Flattened
Did
all
the police arrive?
A witness seen the incident and she called the police.
Okay, but after that happened, did the police arrive?
Yes, sir.
All right. And were you arrested?
Yes.
All right. And were you taken to the hospital or were you taken to the police station?
Yeah. I was taken to the hospital.
All right. And there was a blood draw?
Yes, sir.
All right. And what were the results of that blood draw?
It was a .181, Your Honor.
Ooh. Wow.
So do you have any reason to dispute those blood test results?
No, sir.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, sir.
All right. And had you previously been convicted of operating while impaired on or about February 25th, 2021 in the 17th District Court?
Yes, sir.
All right. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied, Your Honor. Thank you.
The court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment, and if he has a recent one and it meets with Ms. Polaris' approval, he can use that one, but I'm going to refer him to Von Schwartz, as also the victim's impact panel. Sentencing in this matter will be July 12th?
Yes, sir.
July 12th, 2023, 9 a.m.
Thank you, Your Honor.
Bond in this matter will continue. Okay.
Thank you, Your Honor.
Thank you. We're going to put you into a room with probation intake so we can start the process. Okay, sir? So we'll put you into a breakout room. Hold on the line.
Okay, sir.
Thank you.
He's going to go talk to probation.
Thank you, Mr. Shan.
Keith is putting on deodorant, I think, right now.
Court calls the case, People versus Francis Mahoney.
Raise your hand if you're sure.
Parma Dadush on behalf of the people.
David Shan, on behalf of Francis Mahoney, Your Honor, who is appearing via Zoom. Frank, can you unmute yourself and please state your name for the record?
He's trying to unmute here.
Francis Mahoney. There he is. Okay. All right. What are we doing?
Your Honor, we asked for an opportunity for Frank to do 90 meetings in 90 days, which he did. But there are a couple of violations that need to be addressed that took place during that 90-day period of time, and we would like an opportunity to present the court. He did have ETGs done on the dates that he was alleged to have consumed alcohol, and we believe we're going to be able to address all the violations, other than the fact that the times that he missed when he tested late. We do not have any excuse for that.
All right, well, let me just ask you this. When you're talking about violations, where'd they put them? Okay, I see. You're talking about the SoberLink violations.
His back
Correct, Your Honor.
Keith. Keith, my friend, you're on camera.
So the ETGs, have those been, you said those were done?
Yes, Your Honor, and were submitted to prosecution. And we do believe we have the proper documentation to cover those. There were other violations of the SoberLink by him testing late on the SoberLink, yeah. But all the tests were negative. But there's nothing I can do to help. Frank wasn't drinking, but he certainly is unorganized and did not do the testing on time as ordered by the court.
Anything from the people that you were looking to do in this?
Your Honor, there on his community corrections violations report, there is almost 2 pages of missed tests or rescheduled tests that were missed. On 5/19, which is the latest notification of the drug testing at 4:10 p.m., the defendant blew a .03. And he was required to retest every 15 minutes until he completed a compliant test, and he failed to do so. Yeah.
My main concern, Your Honor, is not the 5/19. I mean, that is concerning, but on 4/15, the .332 is my main concern. I mean, that's extremely intoxicated. And I did have a long conversation with Mr. Shand about this before I agreed to that 90-day adjournment on the record. If you recall, that I was in favor of it so that he could get some time in. I fully trust Mr. Shand, and I'm sure his client probably told him that he could do it. And while he did do the 90 meetings, to my understanding, this is not acceptable behavior. And regardless if he's doing the meetings and or getting treatment, this kind of violation report I would be asking for a remand.
Mr. Shand.
Well, Your Honor, on the date in question, the 4/15, where there was a 332, he did not retest, and they missed 5 or 6 times to retest. However, he tested between 9 and 12 that same day, and there was not a violation. I don't know what happened that day. I've asked my client. He said he did not drink. Though that was one of the only 2 times in the 90 days that he actually had any type of alcohol in his breath.
On the 15th, he's saying he did not drink?
He did not. And at the test that he took between 9 and 12 that day, he ended up passing that test because it's not a violation.
It was 0.03.
And I don't know why there would be such an aberration, 0.332. Obviously I've known Frank for a long time, and I know the way he drinks. He's a 1/5 to a 1/2 gallon a day of vodka drinker. So if he was at 0.332, I don't think I would have ever seen him again. But obviously that night he passed between 9 and 12 because there's not a violation. And on the 19th of May, when he did he had very low numbers, 0.03, he had an ETG done the very next morning, and he passed. It was negative. So we have an ETG report from 5/20 at 11 o'clock in the morning, and he was negative.
I'm going to need Francis to do a quick little breathalyzer right now.
Okay, and maybe you're referring to the absence of a test or an absence of a report.
Correct. There was if he was testing 3 times a day, if he had missed the 9 to 12 that day, it would have been a violation. He didn't miss, and it's not a violation, which means that he did not blow any numbers. If he blew 0.332 at 2:50 in the afternoon, the 9 to midnight blow, he would have blown some numbers, because there's no way that much alcohol can be out of your system by the 9 o'clock test. It's not a violation. It was not a violation at 9 to 12. The fact that he missed all those retests is concerning, because he should have been testing. And I don't have any excuse for that. However, the fact that he passed the test at 9 to midnight on the same day that he blew 3s in the afternoon doesn't make any sense to me.
He blew 3s.
And as your honor very well know, I was a guy that blew 3s on a regular basis, because you put me in jail because of that a couple of times. So I don't understand why there was such an aberration in the testing, because he should not have been able to pass that evening, and he should have it should be a violation for either not testing or failing between 9 and midnight.
Wow. The lawyer knows his stuff because he's been there. He's like,
I would tend to agree with Mr. Shand on that, because I'm concerned. On the 19th, is he saying that was also some aberration?
Well, he said he brushed his teeth and used mouthwash. I know. I said that's been heard by Judge Simpson about 73,000 times over the last 25 years. So, however, he did call me about that, and I said, you need to get an EKG done. And he did go the very next morning, an EKG done on the 20th of May, and that was negative.
Okay.
So he used a little scope, a little bit of Listerine.
I'm a little bit worried about this report also, because I'm looking at this, and I think Mr. Shand's right. I mean, if you look at just, unless he has some extraordinary elimination rate, he's... that 415 test, I'm assuming he took a test.
We're going to be back with the trial in just a minute. This is a just brief break.
But they're only listing the violations. Therefore, if he took the test later and he violated, it would be a violation. He took the test later and passed.
So he was blowing straight 3s, 0.333s.
I've seen it laid out both ways. So, but I get your point. I mean, I've seen it where they then tell me when the next good test is. So at least we have a framework. Here, I'd be making an assumption, but he would have had to test on the 16th, 17th, and I don't see that. Well,
we're here for James and Cynthia.
What I would do is I would set this for a hearing, because I got to have some understanding of why it's a 3-3. I would agree with you that if there is a past test, that's not going to make sense in terms of just how a human eliminates alcohol. So
got a super liver.
I will set it for a hearing on the bond violations.
Tell you, if he's figured out how to get rid of 0.33 percentage alcohol from your blood in a couple hours, the guy's going to be a millionaire.
I'll set the bond violation hearing for June 21st, 2023 at 3:30. In the interim, however, Mr. Mahoney, I'm not doing this to punish you for bond violations I haven't found. My problem that I'm having here is you're not testing timely.
Yes, sir.
So, or regularly. Okay. So I'm going to order in the interim between now and then that the defendant is to report to community corrections for placement on a scram tether.
That would be fine, Your Honor. I think that would be really helpful too, because I sent a long email to Caitlin explaining Frank's retired and his schedule is not a set schedule, and he seems to have problems testing at the right time. And I think a scram tether will be able to give everybody a clearer picture of exactly what's going on. And I have no objection to him continuing on tether either. Even after we have this case resolved, because I want him to be comfortable. I'm not just his lawyer. I'm his grand sponsor too. His sponsor is a guy that I sponsor. So we talk a lot, and I'm really interested in his continued recovery. He has been doing really well so far.
Okay. So what I'm going to do, you understand that, sir?
Yes, sir.
All right. You need to get yourself over to community corrections today. Get that switched, and then we'll see you on the 21st at 3:30 for the bond violation here.
Yes, sir.
Is that via Zoom, Your Honor, or in person?
That's going to be in person.
Okay. I get to see Miss Kirby.
Yes.
That's everyone's favorite thing to do.
Well, actually, I get to see Judge Simpson. That's the highlight.
No, I'm not going to talk to any of you. All right. Anyway. All right. Take care. Thank you.
Thank you, Your Honor. Thanks, Caleb.
Bond will continue in all other aspects. Court does call the case of the people versus Heather Ferguson.
Barbara Dadush on behalf of the people.
Silvana Reed, Assistant Public Defender on behalf of Ms. Ferguson. If you are present, could you please unmute and state your name for the record?
Heather Lynn Ferguson.
Thank you. Your Honor, I was not able to make contact with my client. Ms. Ferguson, if you could call our office and make sure that we have a correct phone number and email address for you.
Is that the 222-690 number?
Oh, sorry.
Yes, that is correct.
Okay.
I didn't want her to give her number.
I'll adjourn this matter to June 21st, 2023, 9 a.m., as your Zoom invite indicates. Thank you. Bond continued. Court calls case, People versus Cooper Gardia.
Barbara Dadush on behalf of the people.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Gardia. Mr. Gardia, if you are present, could you please unmute and state your name for the record?
I haven't checked in.
Not checked in.
I have no further information as to his whereabouts.
And we've been going through it. We also have not receiving any results from any testing.
I did contact him and told him to get in contact with the facility I know that he has been doing the testing. It's just been an issue of the facility sending the results over.
Well, that's fine, except that May 11th, I mean, we didn't have results back in April and May, the beginning of May, and I thought we had gotten that clarified. But then from the 11th, we're about to head into almost a month of no results.
I played the crickets.
So a bench warrant will issue for the defendant's failure to appear. Bond will be set in the amount of $50,000 cash surety.
Go and get him.
That warrant will issue immediately. Thank you.
James and Cynthia have their
Court
paper.
calls the case of the people versus Mahar Kasham.
Karma Dadush on behalf of the people.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Kasham. Could you please unmute and state your name for the record, sir?
Mahar Kasham.
Thank you. Your Honor, this is an instance where Mr. Kasham has quite a bit of time before he is able to reapply for his license. So I did inform him of the standard offer from the prosecutor's office to plead to the no ops on person, and he has agreed to take advantage of that.
Which charge?
No ops on person.
No ops on person. Operator's license.
Okay, I get it. Okay. And that is the offer of the people?
Yes, Your Honor.
All right.
I don't like that they're making
Mr.
James
Kasham, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record, please.
Mahar Kasham.
All right. So it is this court's understanding that you're going to plead guilty to the charge of no valid operator's license on person. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that? Actually, it's one.
Yes, Your Honor.
Well, it should be a $100 fine plus court costs. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
I am.
Of your own free will?
Yes, Your Honor.
And because you believe that you're guilty of this offense, sir?
Yes, Your Honor.
On the date of April 16, 2023, at the location of South State Street near Ellsworth, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Did you get stopped by the police?
I did.
Did they ask you for a driver's license?
They did.
And were you unable to give them a valid license, sir?
Yes, Your Honor. I was not able to give them a valid license.
All right. Thank you. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is also satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Sir, anything you want to tell me before I impose fines and costs?
No, Your Honor.
Fines and costs of $300. I'll suspend 90 days in jail. When can you get that paid, you think, sir?
I should be able to get paid sometime this week. or maybe early next week.
Okay, so you're just waiting on a paycheck or something? Is that what you're looking at?
He doesn't have a license.
All right. Today's what, the 7th? So you can get it paid by not this Friday, but the next Friday for sure?
Absolutely.
Okay.
Sorry.
Then I'll just indicate you're going to pay it by the 16th, June 16th. Okay?
Thank you, Your Honor.
All right, thank you. You're all set. Take care.
You too.
So he might have to do 90 days time.
Court calls the case, People versus Russell Keene.
Karma Dadush on behalf of the people.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Keene. Mr. Keene, could you please unmute and state your name for the record?
My name is Russell Keene.
Here we go.
Thank you. Yes, we can hear you. Okay. Your Honor, we would like to ask for one brief adjournment in this matter to continue negotiations with the prosecutor.
Adjourned June 21st, 2023, 9 a.m. Bond continued.
Thank you.
Thank you.
That was quick.
Court calls the case of the People versus Keith Malone.
Karma Dadush on behalf of the people.
Keith, front and center.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Malone. Mr. Malone, could you please unmute and state your name for the record?
Unmute.
You're still muted, sir.
No, he said it wonderfully. It's just I can't hear him.
My name is Keith Bill Malone.
Thank you.
Okay, there he is. All right.
Your
What
Honor,
are we doing?
I was hoping to ask for an adjournment in this matter. Mr. Malone also has a felony case for which there's an offer to reduce it to a misdemeanor if he completes treatment. He's completed treatment. He is now literally just yesterday moved into transitional housing. So he is doing very well. And that case would be handed down to this misdemeanor docket. And so I was hoping to adjourn it so that we can try to get both of these cases coinciding on the same.
How far out? He just started transitional?
Yes, but he has completed the treatment. His next PCC date, I believe, is the 22nd. And I have forwarded his certificate of completion both to Ms. Kirby as well as my coworker who's handling his felony case so that can be provided.
June 5th or July 5th, 2023, 9 a.m.
Thank you.
Hey, Judge Simpson.
Yes, sir.
Hey, I heard you called me, huh?
I called you.
Something from the office to Judge Simpson or something like that. That's all I was doing. Somebody did from your office.
Nobody. I'm sorry. I don't know what you're talking about.
Somebody said somebody got a call from Judge Simpson's office. I don't know. But I'm doing good. And the 90 days really did a good thing for me. I'm going to thank the court and everybody that helped me out. They got to find a new foundation, get a new lifestyle. I've been clean since December 5th, 2020. So I'm doing good, man. I don't think I'm going to go back out there. And, to help everybody else, I got to give back into this program. It's a simple program. As long as I keep it, don't pick up. Because life is short for a lot of people. And I've been doing this stuff 36 years. And I'm tired, man, And I'm thankful for the help. I'm thankful for Dow's Farm. And I got to do what I got to do. It's up to me to do it. Nobody else can change you. Change yourself but yourself. So thank you, sir.
All right. You just keep it up. Because you know how I am. So if you go back to that other way, I'll be out there in the street somewhere. I'll roll up on you. Then I'm just going to grab you. You know that, right?
Yes, sir.
All right. All right, Mr. Malone. You take care of yourself, fella.
Yeah, thank you.
Nick, welcome to the gallery. Terrence Moore is about to lead us in yoga.
Case, People versus Sarah, is it Malkowski?
Silvana Reed, Assistant Public Defender on behalf of Sarah Michalski. Ms. Michalski, if you are present, could you please unmute and state your name for the record?
Oops. Oh, gosh.
That was happening. Okay. We're not here. Bench warrant will issue for defendant's failure to appear. Bond $5,000. Give a 10% privilege. That warrant will not issue until June 9th, 2023.
Miss Chris, thank you for
Court calls
continued
case of
support.
the people
5 months.
versus. We're gonna write the whole thing. I gotta be able to read it. Janae Miller.
Herma Dadish on behalf of the people.
Silvana Reed, Assistant Public Defender with and on behalf of Ms. Miller. Ms. Miller, could you please unmute and state your name for the record?
What the heck?
Do we need a Kersey counter?
Is that them?
No, but she is here. She's trying.
She's trying to. Oh, there she is.
I think we need the Kersey counter.
Hello, what's your name?
Janae Miller.
Thank you. All right, what are we doing?
Your Honor, today Ms. Miller is planning to plead as charged with the prosecutor deferred offer.
For disturbing the peace?
Yes.
And please raise your right hand.
Jury and Travis trial in court with questions.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record, please.
Janae Miller.
Okay, the anxiety.
It is this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court cost. You understand that?
Yes.
You still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you're indeed guilty?
Yes.
On
Eric's smoking a cloud.
May
down there.
13, 2023, location 2401 Glencoe Hills Drive, Pittsfield Township, Washington County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
Disturb the peace.
Okay, that's a conclusion. But what happened on that day? Were you at a healthcare facility?
Was I at a healthcare facility? No, I was walking and the police, they pulled up on me and they said that I had blood on me, my feet and my hands was cut up, and they took me to the hospital. They said I was intoxicated, but I was
okay.
lost. But it's a long story.
It's a long story, but I'm going to plead guilty to it.
But you were walking up the street you were in the area of Trinity House. I guess it just says
I believe they took her there.
When you got to the hospital.
I was basically lost. Yes, I was basically lost.
Okay. But when you got to the hospital, what happened there?
What happened there? I really don't remember that much, but I know that I was lost and they took me to the hospital, and I know they tried to basically sedate me because a man said something probably rude to me and I said something. Huh?
Okay, but you were out of control. Would that be fair to say?
I was under the influence.
Okay. And you being under the influence kind of made you out of control and you started yelling, right?
That's fine.
That's why they were going to try to sedate you?
Yes.
Okay. And you would agree that your behavior what disturb the peace and repose of the area surrounding you. Would you not? Would you agree to that?
Yes, I would agree.
Okay. All right, very good. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is also satisfied.
All right, court will accept the defendant's plea of guilty to this charge. Defendant referred to probation for a pre-sentence investigation and report and consideration of the prosecutor's deferred. Young lady, let me ask you a question. Do you drink much?
No, I don't.
Okay.
You can look at my record. My record is clean. This is my first offense ever, as far as going to court for it. I don't get in no trouble.
I wasn't asking about that. I just asked if you did.
No, I don't.
I worry when somebody's answering more questions than I asked. I'm going to leave it to probation as to whether or not, but you have the court's authority, if necessary, to send her for a screening and assessment. At this point, though, I will just refer over for a pre-sentence investigation and report. Sentencing in this matter will be July 12th, 2023, 9 a.m. Ma'am, hang on, and we're going to put you into a breakout room with probation intake so they can get information and give you instructions. Okay, thank you.
Thank you.
She does not have time for
Court
this.
calls the case, People versus Alexander Mooney.
Kerma Dadush on behalf of the people.
Silvana Reed, Assistant Public Defender, on behalf of Mr. Mooney. Mr. Mooney, if you're present, could you please unmute and state your name for the record?
Mr. Mooney, now's your time.
Do not have.
We don't have him in. Bench warrant will issue for defendant's failure to appear.
That's 3 bench warrants
on
today.
5,000. Give a 10% privilege on that. There has been a previous warrant, so this warrant will issue immediately.
Okay, the pink jumper is back. We saw her last time. She was also with James and Cynthia. Eric was
Court
back.
calls the case, People versus Terrence Moore.
Kerma Dadush on behalf of the people.
Ron Brown appearing on behalf of Terrence Moore.
Terrence is here.
Mr. Moore?
Yes, sir.
Turn on your camera.
Are you able to hear me?
Okay. Yes, I can hear you, sir.
Are you
He's
driving?
iPhone 3. I guess got it. Okay, what are we doing on this case?
Your Honor, I'm requesting an adjournment so that we can get verification of a valid certificate of insurance.
June 21st, 2023, 9 a.m.
Is he driving without insurance?
Bond continue.
Could you repeat that date, Your Honor?
21st.
21st. Thank you.
Thank you.
Oh, can I say something real quick?
If you must.
So all of these notices that I received in the mail from the court, I'm not sure what part from the court to the post office from when the mail gets sent out. But my mail has been coming to my house open. It's been coming to my house open, and I don't even feel safe and secure to even open my own mail. So I just wanted to throw that out there.
Thank you. Court calls the case, People versus Cynthia Pearson.
Cynthia.
Kerma Dadush on behalf of the people.
Ron Brown appearing on behalf of Cynthia Pearson.
Yeah. Ms. Pearson?
Yes, I'm here, Your Honor.
Yes, ma'am. All right, what are we doing on this case?
Your Honor, I'm requesting an adjournment so that my colleague can talk to Ms. Pierce.
I will adjourn this out to June 21st, 2023, 9 a.m.
Man, we got pushed off.
Her bond will continue. I'll call the case of the People versus James Pearson.
Kerma Dadush on behalf of the people.
Can I say something? I have a problem with that date. I have cancer, and I have an MRI scheduled on June 21st.
Okay, that's then, all right, that's fine. Will July 5th work better for you, ma'am?
That's perfect.
All right. Thank you for saying something. So we'll, July 5th, 2023, 9 a.m. And know that you'll be in our prayers, okay?
Thank you.
Bond will continue on that. Court calls the case, People versus James Pearson.
On behalf of the people, Your Honor.
Ron Brown appearing on behalf of Mr. Pearson.
Okay, so I don't know if that's going to be able to continue or not, because I think they're co-defendants.
We'll explore that with them if the court be gracious enough to grant an adjournment, and I can contact Ms. Hightower Brown if possible.
Well, yeah, okay. And I don't see. I'd grant it for Miss Pearson. I don't know about Mr. Pearson. No, I'm kidding. I'll give him the adjournment too. How are you, Mr. Pearson?
Better that you're smiling, sir.
No, I have to say this, Mr. Brown. They always appear there. And I think it's been 2 or 3 times they appear. And I have to say my staff was up. Oh, no, I don't say upset. Were we?
We were not upset.
We were not upset. But the other times that they've appeared, they've actually been dressed alike. They look so cute together. And this time they showed up and they weren't. And we're like, okay, what's going on? And so I figured that the reason that they weren't that way, he did something he shouldn't have done. So I was blaming him for the whole thing. But I was just guessing. So I didn't know. Anyway.
On advice of counsel, happy wife, happy life.
He's not going to say anything. I know. Okay. Let's adjourn this out then to July 5th, 2023 at 9 a.m. Defendant's bond will continue. Okay, Mr. Pearson, you guys take care of each other, please.
Thank you, sir.
Thank you.
Court calls the case. People versus Carlita Piesky.
Kerma Dadish on behalf of the people.
Do you want to stick around
Ron
for
Brown appearing on behalf of
Eric and
Piesky.
Pink? Or do you want to jump back to court?
Someone's got a comment.
Can you state your name, ma'am?
Carlita Piesky.
All right. Okay, what are we doing on this?
Notes in my file indicate you will
Let's
plead
switch
as
back.
charged.
We're switching
and
back. All right.
Seek HIDA.
Is that what you want to do, ma'am?
Stay for
Yes, Your
Melinda.
Honor.
Is she the next one?
All right. Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I think Pink Jacket's next.
Yes,
So
sir.
let's stay for her.
State
and then
your
we'll go
name
back.
again,
We'll
please.
jump back to court in just a
Carlita
second.
Piesky.
All right. Well, let me make sure. I have second degree, but it's third degree is charged.
Well, I looked at the police report. It looks like there were a couple episodes with different dates for a total of about 626.93 from Target.
Right, but I think it was charged as
It's another
a
shoplifting case.
third degree, but
Thank you,
my
Tabitha.
file, it was entered as a second degree, and I don't know why.
Well, we prefer the third to save.
No, I know. I know, Mr. Brown. I got that. Can the prosecutor indicate that I think it was charged as a third degree? That's what I'm reading.
It is charged as a third degree, Your Honor.
All right, thank you. Let me just correct this here.
No objection.
That lowers the charges.
He's just been looking for
$650 worth of
adjournment
shoplifting
all
from
day.
Target.
All right.
Ms. Reed is doing such a good job. I just stay out the way.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. Fine could be increased if 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, ma'am?
Yes.
Man, what are these people doing?
And
who aren't
understanding
on
all of
camera?
that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you, and you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal of Ray?
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty to this charge?
Other than being told that this was a misdemeanor, no.
Okay, it is a misdemeanor. All right. Has anybody promised you anything else?
No.
Anybody threaten you or coerce you to get you to plead guilty?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, because I believe that I was guilty.
And you believe that you are guilty. Okay, you anticipated my question. All right. April 12, 2022, at the location of 3749 Carpenter Road, that being the Target store, Pittsfield Township, Washington County, State of Michigan. What did you do on that date that makes you think that you're guilty?
I stole merchandise from the store without paying.
All right. So when you say that, you went into the store and you got merchandise, and is that correct?
Yep.
And you tried to walk out of the store without paying for it?
Yep.
Yes?
Yes.
No, yet.
Store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take that property, did you?
No, I did not.
And this property that you took, this was property that Target had offered for sale?
Yes, sir.
All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and a report and consideration of HIDA. Sentencing in this matter will be July 12th.
Yes, sir.
July 12th, 2023,
So this
9 a.m.
Basically, there's the same
All right.
charges that
Ma'am, I'm
James
gonna
and Cynthia have.
put you, where did you go? Ma'am, I'm gonna put you into a breakout room with the probation department so they can give you some instructions and you can provide them information, okay?
All right. Thank you, sir. Have a wonderful day.
We're trying to stick around just
You
for
too.
Melinda.
Court calls the case, People versus Densnita, I think, Rekovic.
Kerma Dadish on behalf of the people.
Ron Brown appearing on behalf of my client, Your Honor.
She's here. Ma'am, Mr. Brown's client, can you state your name, please?
The name's so hard.
Janetta Rekovic.
Yeah. All right, what are we doing on this case?
Notes in the file say that mental health court forms were forwarded.
Why is she off camera?
That's correct, Your Honor, and they don't have a prosecutor's signature on it. I got the referral form after 5, and Mr. Balbasi sent it in. The court has my permission to sign it.
All right.
She's not wanting to be on camera. Name down there on the bottom is got a lot of energy. If we're alphabetical, I think we were going to feed next, unless there's somebody else who's offline.
So we have that referral in, and how much time are we going to need to try to get through this process?
I think the July 5th date would probably be good.
All right.
So we'll see her
I'll adjourn
next.
this matter to July 5th, 2023, 9 a.m. Defendant's bond will continue. All right. Thank you, Ms. Rekovic.
Thank you.
That's the end of the 11 o'clock.
That's the end of my 11 o'clock. We're running a little bit behind. Give us about 5 minutes to get ourselves set up for the 12 o'clock, and we'll start
We're
right in.
not stick to
standing very
that.
free.
Sorry. We tried, but we can't do that. Okay, here's what we're going to do. We're going to jump back over to trial right where we left off in the middle of the, almost towards the end, actually, of the closing statements by the defense. Defense goes first here. So we're going to just pick up right where we left off here. Play. Get some audio going.
This time about the guns. He gives them what they want. He tells them he saw the guns, he saw Adam with the guns, he was there for the sale, and he saw the buyer up close.
Okay.
But when Attorney Smith questioned him, you heard that when the police took Mike Sullivan on the ride-along to corroborate his story, he couldn't even find the house.
Thanks for indulging me. That was awesome. James and Cynthia. We'll be back with them on July 5th.
Mike said he got a close-up look at the buyer of the gun Adam had in his trunk, and yet he never identifies anyone, and the police do not do a photo lineup. When asked, Mike tells him he saw the AR-15, and another time he tells them he saw the shotgun. When he testified here, he said he could only see the barrel and the butt, and it was covered in a sheet. Mike cooperated, and you heard that his charges were dropped. The police talked to Kayla. At this time, Kayla was also in jail for the guns. She had charges for receiving the same 2 guns that Adam's charged with. The 2 guns from the Frayne residence.
I'm going to see if I can
told
speed this
you
up
she
just a
didn't
tiny
do
bit.
it, and that her and her attorney had gone over the police reports, and that she was going to court to contest the charges at a hearing. Then the state makes an agreement with her. As part of that agreement, she's released on bail. And now Kayla wants to cooperate with the police. And she tells the police what they want to know about the guns. She agreed that when she spoke to the police, she had the benefit of the police reports, she had spoken with her attorney, and she had spoken with others about the case, like Tara Hilbert. After Kayla spoke with the police, the charges of receiving stolen property for the guns were dropped. Her welfare charges were dropped. But she was convicted of perjury, lying to the grand jury during the state's investigation, lying under oath. Adam Montgomery is a convicted liar. The police then go to Mark Reed. At this time, Mark's in the prison. And he tells the police that Adam did message him about moving guns. Adam contacted him on Facebook Messenger, and he had photos and said he needed to move the guns quickly. Mark tried to negotiate a deal and received a message from Adam too late. Mark told you that he never saw Adam with the guns. He never saw the guns. Just the Facebook message about a deal. The police contacted Kevin LaBelle in 2022. At that time, Kevin was in a halfway house. But the police talked to him about information they had gathered. And the police asked him if he had bought a gun from Adam. And Kevin LaBelle said no. In 2023, the police go back to talk to Kevin LaBelle. This time, he's back in prison. He has a new charge. This time, Kevin tells the police he bought the gun from Adam. He held the gun, and he fired it off. Kevin checked all the boxes. And in fact, you saw Kevin LaBelle testify. And he wanted you to know that Adam sold him the gun, he held it, and they fired it. In fact, Kevin gave that answer to almost every question he was asked. But when Attorney Smith cross-examined him, let's think about his ability to remember other information. He couldn't remember what time of year he bought that gun. He couldn't remember what time of day. He couldn't remember his own criminal convictions.
Objection, Your Honor. Facts not evidence.
Overruled.
Approach.
Not testimony. We did. We're getting a little bit of a catch up here. We're going to catch up as I believe we're now probably in. I don't know where we're at. Let's see.
The objection's overruled.
I think we're still prosecution's closing in real time.
He could not remember where he worked. When Attorney Smith asked him to read his prior testimony, he said he couldn't read it. He had a concussion. But when the state asked him about his immunity letter and to read that, he had no problem. And he had no problem testifying that Adam had the gun and held it. Kevin LaBelle also got his consideration. In fact, the day before he testified, he told you that he had a felony charge reduced to a misdemeanor, and he received no additional time. You heard from Tara Hilbert. She was contacted by the police, and she told you that she continued to be friends even when Kayla was incarcerated. And her story supported Kayla, but she never saw the guns. The police spoke to her fiancé, Josh Zimmerman, 6 months later, and he told you that he had spoken with Tara after her interview, and his story was similar, but he never saw the guns. And what about the physical evidence, the science-based evidence, fingerprints, DNA? An officer told you that he recognized powder as if the AR-15 had been tested for prints. He talked about the evidence tape on the box indicating it had gone to the state lab. And yet you've heard nothing from the state about any information or results. What does that tell you? That science-based information does not show Adam had the guns. On April 1st, 2022, Adam was arrested for selling the guns. On April 4th, 2022, Kayla was arrested for receiving the guns. Her charges were dropped after she spoke. The state wants you to believe that all of their witnesses are saying the same thing, but if you look closely at each one of the inconsistencies, each one has a possible motive to help themselves or another. The testimony you have heard is like what I mentioned, a game of telephone. What happened to the guns? Stole, traded, bartered, pawned. What guns? The AR, the .38, the rifle, the long gun, the handgun, the big gun. Who knew something? Chris, Manny, Kim, Mike, Adam, Mark, Kevin, Tara, Josh. Where were the guns? In the attic, in a trunk, at a house, in the walls, in a ceiling. Who bought the guns? 2 white guys, a Hispanic guy, 2 black guys. What were the guns in? A blanket, a sheet, in cases. The state has to prove these charges to you beyond a reasonable doubt. And when you look at the testimony and evidence in this case, there is doubt. The inconsistencies cannot be made into one consistent, believable story. For example, the theft of the guns from Kim's house. You can see this in different scenarios. Kim needed drugs, but she was out of money. She reached out to her dealer, Ish, but did not hear back, so she called Adam. But before Adam arrived, Ish came over and gave her the drugs she needed. In turn, she gave him the drugs. Adam arrived. She was passed out from the drugs after being up for 3 days. She bartered for the drugs, allowed the guns to be used, and returned before Chris was home. Chris came home early. The police were called, and the guns had to be getting rid of. Or another scenario, Kim called Adam and he came over. They were both in need of drugs. They called for the drugs, but no one came. Adam left before Ish came over, and Kim exchanged the guns for drugs when Adam was gone. Or a third, Adam came over when Kim called. They did drugs. She went to sleep. He took the guns and took them home. If any one of these scenarios is reasonable, then there is reasonable doubt. The same is for the sale of the guns. Based on what you heard, you could conclude that Adam did help Ish in selling the guns, based on the photographs. He never had the guns, therefore he did not possess or control them. Or in another scenario, looking at the evidence, you could conclude that Ish came to Adam trying to sell the guns. Adam didn't have money, but offered to help Ish move the guns in exchange for drugs.
Sustained.
If both of these are reasonable, That is reasonable doubt. Anyone can accuse a person, even the police. The police wanted Adam Montgomery. They used the police you saw during the trial to try and corroborate their conclusion. The information the police generated using the tools of pressure, threatening, or offering them something they wanted. The evidence that you have heard was manufactured over time for the police. When you base your investigation on a lie, you get the wrong conclusion. At the beginning of this case, you were asked if you could find Adam Montgomery not guilty if the state could not meet their high burden beyond a reasonable doubt. You all agreed that you could. The reason
we did a
to
poll,
find
93%
Adam not
guilty
here today is bigger than just Adam Montgomery or any of the other witnesses. It is to maintain a criminal justice system that does not allow the police to make a single conclusion about a person and then conduct an investigation that only looks for the evidence that supports their conclusion and get the result they are seeking. Adam did not steal Chris Frayn's guns. No one did. Kim lied after she had traded them for drugs. When the police were called, the guns had to be moved. Adam made calls to move those guns. This did not require him to possess them. He communicated with people by phone, text, and Facebook message. Drug dealers do not trust their users. The reason that they're in business is because those folks want drugs. Ish was smart enough not to trust anyone with the guns. He controlled what happened to the guns. Adam made the connections with the people, the potential buyers, but he did not control the guns or who got them. We ask you to find Adam Montgomery not guilty.
Okay, we are going to put together a poll for jury deliberation time. Now we have the closing by the state.
Just to move the television if the jurors need to take a stretch break.
Today, you want to stretch? This would be a good time.
Yoga time. We're putting together a poll right now for jury deliberation time. Just 1 second. If I can spell it correctly. How many options do we need? Less than 1 hour, 1 to 2 hours, 2 to 4 hours. Or last option is or plus 4. Okay, here we go. Oh, that's too long. It's on the menu. There we go. Is that right enough? Did that work? Oh, it's still too long. Now this is a pain in the butt. I wish it gave me more space to. Where's my audio coming from? Why is it clipping? Why do we have no audio? Come on, guys. Do better than this. Okay, here's our poll for the jury deliberations. We have no audio yet right now. I'm going to try to skip ahead because this is just super annoying. And if we're not hearing it anyway. We're getting no audio. There it is.
In a previous
So here's where the audio picks up. So we just cut out a whole bunch.
quotation of what those folks said when they took that stand,
Wow.
or what they said in a previous statement. And is that what you got? It's not.
Well, we caught up. We did a lot of catching up, but we missed everything that happened. So the poll's up right now.
One
Check
thing
out
that I
the,
agreed with Attorney Smith about
the options before you vote.
from these stories that we heard from the folks that came here and testified. Attorney Smith said in her closing that Mike Sullivan came up and he told the truth about his interview, what he knew in his 2020 interview. And we talked extensively about that, what he knew. And she said he told the police that Ish and Manny was there, and he mentioned Adam. Was that what he said? Was that what he testified to when he took the stand? I read his quotations to him. He adopted those. He said, yeah, that's what I said. That's what happened. And what I asked him, you said Ish and Manny took the guns, and Adam had the guns. I couldn't agree more with what Attorney Davis said. He did tell the information that he knew back in 2020. He said Adam had the guns. And then he was asked, did you see the guns? And he said, see him, I held them. The shotgun and the AR-15 rifle, I held them. Adam had the guns. That was his statement. He said, yep, that's what I said. So when we quote people, we want to make sure that we're using the right quotation. And we're encompassing the full story. So the surrounding statements that are associated with that quote, not just picking and choosing. He said Adam had the guns, both guns, the big boys, the two long guns that were stolen that night. And he clarified with us. He told us that when he referred to Ishmael, Garcia, and Manny, he was referring to the pistols. That was his evidence. That was his testimony. That was his truth. So there's the evidence of Ishmael Garcia or Manny. And we should have added during closing some phone call between between Ishmael and the defendant. Where did we hear that? Not a part of this case. Speculation by the defense to fit their story. Adam had the guns.
Alex stole it.
There's another concerning thing that you were told just now, and that's that in 2020, the Manchester police wanted everything they could get on that man. Where did we hear that? Did one of the witnesses say that? Why? Why would the Manchester police care about Adam Montgomery? That's not anything we heard in this case. That they were all out to get Adam Montgomery? For what? Because he possessed guns.
Murder.
When he was told 3 or more times, you can't have guns. Felony conviction after felony conviction after felony conviction, being told, no, you cannot have guns. And still he sold them. He stole them. He possessed them. And he distributed them to people in this city, people like Jonathan Sargent, who was apprehended with it shortly after.
Okay, I'm going to
That's one reason to care about who he is. To concoct stories, to get witnesses to say what you want them to say. What evidence did we hear of that? But they were right. Mr. Sullivan, 2020, came in and told them what he knew. That's what she said. And he did. Adam had the guns. The 2 guns that he's charged with stealing, the 2 guns that he's charged with possessing, and the 2 guns that he's charged with selling or disposing of. The 2 big boys. So there's no evidence of Ishmael Garcia. And that's because it didn't happen. The story that you were just told was just that. It was a story, not based on evidence. I want to continue talking about what this case is not about, ladies and gentlemen.
Why are we talking about what it's not about?
It's not about Mike Sullivan's drug use, his drug addiction, his charge for petty possession. This case is not about that. It's not about Kim Frayne being slumped over, sleeping in a car with drugs on her person. It's not about her drug use. It's not about her addiction. This case isn't about Mark Reed. It's not about the things that he told you he did on the stand, like do drugs, sell meth, sell crack, sell heroin. This case isn't about that. This case isn't about Kayla Montgomery, her drug use. It's not about her conviction for perjury on another matter. It's not about that. But notice that that's what you got a lot of. These convictions, the drug use. People that came in and were open and honest about some of the roughest times in their lives, things they've fought to get out of. It's not about their drug use. and it's not about their charges or convictions. And the defense wants you to focus on those things. They want you to focus on everything this case isn't about. So at the end of the day, you won't see what this case is really about. That man going into his trusted friend's home, stealing from her, betraying her trust. Her trust as an invited guest. And in the time that followed that, possessing firearms, knowing that he couldn't, selling those firearms for drugs or money. That's what this case is about. Don't let those other things distract you. They're a distraction. So with that out of the way, I want to talk about the theme of our story. I want to talk about something that they didn't. I want to talk about the truth. And again, the truth is what you got from the witnesses. It's true they raised many questions. Those weren't relevant questions. Those weren't questions that should give any of you any serious pause when you're considering what the real evidence is in this case. They were attempts to distract you. And again, the truth is he stole those guns, that he possessed them, that he sold them. This is a remarkably simple case. Again, the best evidence in this case, not her statements, but his, the defendant's. What the defendant told us, that's what we're asking you to rely on, his words. And what did he tell us? He told us that he stole the guns. That's a pretty big detail. He told us that he possessed the guns. He told us that he sold the guns. And he told us how he did it, who he betrayed to get them. That's the truth of this case. That's the truth that you were given over the last few days, folks. That's the only truth that there is. And how do we know what the defendant said? Well, he made statements. He told witnesses things. The witnesses that testified to his various statements, drastically inconsistent with one another, but with consistencies that matter, and we'll go over those. So we have his various statements. We have the jail call that you folks just heard, that we listened to just an hour and a half ago. And we have his messages. Those messages frozen in time, as Mark Reed told us. An hour and a half. And so what was his first statement? His statement to his wife. The first thing he told her about this incident, shortly after it occurred. He told her that Kim Frayne was sleeping, that he went to her house. Her door was wide open. Her dog didn't bark. He went there. She was sleeping. He woke her up. She hadn't crashed. She was sleeping. Not crashed. She was asleep. He woke her up and she said, "Oh, my guns are gone." That was the first story that he told. He told his wife. And she came in here and she testified to it. And I guess the rest of that story would have been that he left. And the second story that he told to his wife again, after she confronted him, after she saw him dealing those guns to Ish, to Manny, and to Mike, attempting to sell them what they knew were stolen guns. She confronted him. This was her colleague. This was her friend, a close friend, someone who had done favors for her family. And he told another story. And what was that story? We got it from Ms. Montgomery when she took the stand the other day. She told us that he said, that defendant, I went in, she was sleeping, the dogs didn't bark, I took the guns, I concealed them in a sheet, and I left. And that's consistent with what she saw. She heard him come home afterwards, and the next day he was trying to broker that deal. He was trying to sell those guns to Ishmael Garcia, he was trying to sell the guns to Manny, and he was trying to sell the guns to Mike, and they said no, because they knew the guns had been stolen. And then we have his third statement, and that's from the jail call, again, that we just listened to. He was there. He was hanging out with her. They were hanging out. She started falling asleep. Again, falling asleep, not crashing, not nodding off. She was falling asleep. He said goodbye, and he jetted. That's the story, the third story that you just got about what happened that evening. And then you also heard a fourth statement from Michael Sullivan. He told us what the defendant said, and he told us the manner in which the defendant said it. He'd been confronted about the cameras that Ms. Frayne said her neighbors had, pointed at her house. That confrontation while the defendant was doing drugs with Mike Sullivan. And remember what Mike Sullivan said. He said that his wife, the defendant said that his wife was getting ill. She was getting dope sick. He needed more drugs. And I gave him more drugs for his wife to prevent her from being ill. Because it's so bad when you're drug sick. You need more. You need a little more to hold you over so you don't get ill, so you can control your bowels. And that's what was happening to Kayla. And what did the defendant do? What did we hear the defendant did with those drugs that he'd been given for his wife? He took them himself. And why did that matter? Why did it matter that Mr. Sullivan told us that story? It's why he was in the car with him next. It's why he left with him, to ensure that the defendant didn't do more drugs that were intended for his wife, to prevent her from becoming ill. And that's when the defendant first told Mike Sullivan that he'd stolen the guns. If she had those cameras, I would already be in jail. Not Ish, not Manny, me. I would be in jail. And we heard that she didn't really have cameras. If she had those cameras, I would already be in jail. And ladies and gentlemen, we also have the defendant's own statements, frozen in time. His Facebook messages from the day after he stole the guns, trying to get rid of them. The defense wants you to believe this was him brokering. And I think that means we need to look at the actual messages, and we need to go through those messages, and we need to see what this man is actually saying in those messages, because that tells all. And Your Honor, if the jury can just be told that they can move if they need to see.
You can move if you need to.
And ladies and gentlemen, you'll get these when you go back to deliberate. So the first message, the first call. So this is a call from the defendant to Mr. Reed. And importantly, it's dated October 3rd, 2019 at 10:26 a.m. Yo, Mark, hit me up, dog. I got something you're really gonna like. You gotta hit me up now, ASAP. You're gonna miss out, bro. You don't hit me up right now. Shit, girl's phone or something to call and call. I got something you're really gonna like. I do. It's not saying Ish, not Manny, not the boogeyman that you haven't heard of. You gotta hit me up now. Not someone else, me. If you don't hit me up now, and he provides phone numbers. And the first one, it appears to be a typo, and he clarifies that in the second number that he provides. And when I say he, I'm referring to the defendant. He sent these messages. That's not in dispute in this case, from his fingertips. And how can they be disputed? 858-3393. That's the number that he provides. Why is that important? He provided that number on October 3rd, 2019. And we heard that when Jonathan Sargent was apprehended with one of the stolen guns, in addition to everything else he had, the meth, the pounds of meth, the money, all those other drugs, or all those other guns rather, that number was in his phone under a contact named Montgomery Adam. And you heard what wasn't in his phone. You heard there was no Ishmael Garcia, no Manny. The police looked. Why would they look for other information that would rule other people or make them suspects in this case if they had blinders on for this man? Why look for evidence that would refute that he was the only person that stole those guns, that he was the only person that possessed those guns, if they had blinders on for one person, for some unknown reason? That number of the defendants tied to that gun, or that man that had that gun in his phone under Montgomery Adam. Someone that was later sentenced to 13 years in prison for possessing that gun. Someone that dealt in meth. And why is that important? We'll get to that. Oh, then you're gonna miss out because I'm not messaging this shit. I'm not messaging this. I don't want it on Messenger, I don't want it on Facebook. I don't want it preserved in time for a future investigation into what I'm doing. I don't want it on Messenger. I'm not messaging it. There's a house phone there. You guys have cell phones out there. You guys have some type of service. And just before that top message there, you're gonna miss out. We know from Exhibit 35, which you'll get when you go back to deliberate, that Mr. Reed responded to the defendant. And we know what he said. He said, "Yo, what up?" To which the defendant responded, "Do you not get, I said call?" And Mark Reed responded to that, "I can't right now, bro. I'm in Bristol." And then we have these messages. So Mark Reed responds, yo, what's up? I don't want this on Facebook. Call me. And he gave his number. Facebook is too choppy. It's too notch. I don't need stuff like this on message and then on Facebook, dog, you got? I don't want it on Facebook. I don't want it on Messenger. I don't want it preserved in time. What's the defendant so concerned about here? What's he worried about being captured or memorialized? It's evidence of his crime. It's evidence of his criminal conduct. It's evidence of those firearms. And here they are. I have something right now that you've been looking for. For grip, bro. Hit me up ASAP. Hit me up. I have something. Not someone else, not some mystery man. I do. And Mark Reed responds, if it's metal, I want it. And Mark Reed came here and he told us what metal meant when he was sending that message. He was talking about firearms. If it's metal, I want it. And you heard him say, it was easy to move firearms. Quick money or firearms. The defendant responded, it is, bro. The big boys. Remarkably simple case, ladies and gentlemen. It's the big boys. The big boy metal. Mark Reed responds, how much? Remember, he's interested. I can't hold it. First come, first serve. First come, first serve. This man was in a rush to get rid of stolen property, property that he had stolen. He didn't want to be caught with him. And then what do we have here? We have the unsent Facebook messages. And when Mark Reed was here, I asked him, what was in those messages? And he looked at all of you and he told you what the messages contained. There were pictures of an AR-15, Stag Arms AR-15, and a Mossberg 500 pump-action shotgun, a 12-gauge. The two guns that had been stolen the night before, stolen by Adam Montgomery. Why did he unsend those messages? It's what we've been talking about. He didn't want evidence of his crime preserved in time. Mark Reed was able to come here and talk about it, though, tell you exactly what he saw then. We also have the context of the rest of the messages that explain what he saw. I want, or how much I want. To which the defendant responded, which one do you want? Both of them or which one? So we're talking about two items, both or which one? Price of each. And then there's another message that's unsent. And then the defendant says, but we can work something out. What's some other stuff? This is why I need you to call me. But I literally have people blowing me up right now as we speak. But you my dude, so I called you first. I literally have people blowing me up right now as we speak. And he saw that there's another missed call. He's trying to get a hold of this individual, trying to call him. Mark Reed says, I want the 12 gauge, but I don't got 3V. I want the 12 gauge. Again, the Mossberg 500 shotgun, pump action, 12 gauge shotgun. But I don't got 3V. Because 8, it'll be pick up and down. And we heard that up is a stimulant, meth or crack. Crack. Up is crack. Down is heroin. And we heard that this is a communication that's disguised. It's talking about drugs, but they're using other words for it. And Mr. Reed explained what those words mean. Up, crack, down, heroin. The defendant responds, I'll take it. Now let's back up to that story that you heard. And I said I was moving on, so I apologize, but I have to say this. The defense story about the defendant being some proxy for someone else, just negotiating the sale for a buddy. You were told that Ishmael Garcia was the defendant's supplier, that he supplied him with drugs. The defense then got up here and said, oh, well, he was selling these guns to get drugs to give to his supplier of drugs. So I'm selling guns to get drugs to give to the person that supplies me drugs. That's what they got up here and told you. I'll take it. How much? I'll take a stick for the pump. And Mark Reed told us that a stick means a stick of heroin or fentanyl. a finger, which is 10 grams. But I also need like $80 cash. And you heard about a message from September 25th where the defendant says that he's facing eviction, that he needs to get the bread. He needs the money. So I'll take a stick for the pump. I will take a stick for the pump. Not Ishmael, not Manny, me. I will. But I also need like $80 cash. I can't wait around, bro. I can't wait around with it, bro. So I mean, if you hit me up before anybody else does, then it's yours. But if somebody else comes here with the bread, then I got to take it. Let's unpack what that statement says. I can't wait around with it. What are we talking about in this conversation? We're talking about the stolen firearms, the big boys. He has them. He can't wait around with them. They're in his possession. So I mean, if you hit me up before anybody else does, remember there's hundreds of other people that he's reached out to that are hitting him up for these guns. And it's yours. But if somebody else comes here, I'm going to sell them. Here to my house. Remarkably simple case, folks. A conversation so frozen in time. He puts himself with the guns that he had just stolen, and now he's offering them for sale. If somebody comes here with the bread, then I gotta take it. Because we need the bread ASAP, bro. And what else does he say? We're about to be kicked out of my any day now house. And I told you about the earlier message. And again, you're gonna get all these messages. You're gonna get the actual verbatim statements. You'll also get these photographs. If somebody comes here to my house, we are about to be kicked out any day now. And you heard from Kayla. She told you who lived with him back then. The defendant, herself, their 3 children, Seamus, Declan, and Harmony. Ishmael didn't live with him. Remarkably simple. Ishmael wasn't one of their housemates. Manny wasn't one of their housemates. The 2 of them and their 3 children. And then we have the messages from later on that day, almost 3 o'clock, where Marguerite says, yo, remember he's interested. Yo. And then a phone call. The defendant calling him. And again, this is on October 3rd around 3 p.m. The defendant says, you missed out. And what's the next communication, folks? October 2nd, or October 7th. October 7th, just a few days later, and what is the defendant saying? Got fire up and down, and Tina. Let's unpack that statement. He's offering these guns for sale, for drugs, for money. He says you missed out. And then what does he say here? He's saying I have drugs. Got fire, up, crack, down, heroin, and Tina. And what did tell us Tina means in drug language? He said it means methamphetamine, crystal meth. And who sold crystal meth back then? And who had the defendant's number in his phone back then? Under Montgomery, Adam.
And they just having all sorts of problems. Let's see if we can skip ahead. See if I can play it from a different source. Everything's down. Let me see if I can get this one to work here. Why does everything crash all at once? Now we might have to. It's like they don't want us to watch the closing statements. We jump over to view here. Weird. Why would that not work? Anybody, who's in charge of the internet today? 80s Music Man? I showed we had half an hour left of the prosecution droning on about those same screenshots. Give me just 1 second. Let's see if we can find, if it'll pop back up here. We'll reload it here. Oh, it completely dropped that stream. I'm blaming the new cameraman. Let's see. Full playlist. Yeah, we lost it. Look at that. I'm blaming 80s Music Man. Ishcraft that's crashed the system. We're in verdict watch, I believe. Is it okay to call now? Lee, yeah, go ahead. Please call in. We need you desperately right now. Yes. Let's see if we can get Lee on the phone here. We're in silent mode. No, all the feeds dropped. YouTube's having some serious issues.
Call from
Lee.
Hey, Lee, recovery addict here. How are you doing?
I'm good.
Good. We before you start, let me tell you what we did. We bailed on you just for a minute. We ran over to Judge Cedric Simpson's courtroom to follow up on an older couple who were accused of shoplifting. We followed them before. We wanted to follow what happened today. They were live in court. We had to catch that live.
What was the outcome of that?
It got put off until July 5th. They're going to talk to the lawyers a little bit more, so we'll have to go back again. But had some funny discussion with the judge and everything. That was good. It was good to see them. We came back. We got to the end of the prosecutors' closing, and then the audio in the courtroom cut out. We just heard like drumming sounds, like that. For I don't know, the first 20 minutes of the prosecutors' close. Then we heard up through. When they were talking about text messages back and forth about the big boys and things like that. And then the feed is completely down. Like the video's dropped. It's gone.
Oh, wow.
So I need you to tell us everything that happened today.
All right. Let me see. What can I start with? I'll start with first. Before we went in, we chatted with Chris, who's the tall prosecutor.
Yes, did the closing.
He was very friendly. Yep, he's the guy who did closing. Yep, he was very friendly. And the one little, I don't think it's a little scoop, but it will be the same prosecution team for the murder trial.
Okay. Do you know if it's the same defense?
I don't know that.
Okay.
I mean, I would kind of guess it probably will be, but yeah. I don't know. I kind of hope not, but. All right, so let me see. Yeah, so the defense closing, did you get to see that, or is that the one where break apart too?
We cut it in half, but we got to watch all of it. So we covered that. It's mostly there was once the slideshow started, it was like quiet until the slideshow started. I think we just heard clicking sounds, and then afterwards, I think the source we were using pulled the feed because it was so bad. But so now we just have
that's too bad. We couldn't really tell when that happened or not. So yeah, I'm trying to think. So observations on the closing. I thought the prosecution closing was very effective.
Is the jury attentive during that?
Yeah, I mean they were very attentive during the defense closing too. I think the prosecution was very effective in sort of pointing out that this is. That they're trying to sort of paint a story that's not facts and evidence and all that stuff. In a way, I think it was kind of useful that the prosecution did not call Ish, because I think it sort of took a little wind out of the defense's sails, because they kept referring to Ish all throughout their closing, but Ish wasn't part of the evidence, really.
Yeah. For someone who's been talked about probably, 50 times during court, we never heard from him. We heard what Ish said to people. We heard what people said to Ish, but we never heard from Ish. Surprised us a little bit.
Yeah, I had my suspicions we weren't going to see him just for, probably his own Fifth Amendment and pending cases, and probably a generally not believable guy.
Yeah, it probably wasn't the best of witnesses as far as reliability and believability goes. So we basically got a rehash. The prosecution came across with a pretty strong closing, saying, it's his own words, the defendant's own words, are what convict him here. We've got it in text, we've got it in testimony to all these different people, and then as far as jury instructions, those are generally pretty standard. Were there any specific things you read about that we missed?
I don't think there was anything notable there.
Were they told anything about any lesser included charges or?
Nope.
So it's just straight up the
I think for some of the charges, I don't, even if they somehow don't believe in the theft part, there's still the whole possession part and trying to dispose of the weapons, sell them, that I think will trigger the career criminal thing. So I don't know if that's going to matter that much, but I'll be very surprised, I think, if they don't come back pretty quickly with everything.
Okay. Are you planning to stick around and sort of feel the vibe?
We are going to stick around.
Okay.
Yeah, we're sort of sitting in our car outside the thing having a homemade lunch.
Awesome. Would you be willing to give us a buzz if you hear some activity before we hear it?
Yep.
We're getting ready to pick up on our next case, which is Scott Peterson. Big case. It's going to take a lot of time, but we want to catch the verdict, which we hope will come in today. It sounds like it should be.
It will be. I forgot to mention when we were at the Castiglione case, we were sitting out in the lobby, sort of waiting on verdict watch, and the way we could tell it came out it was kind of funny. All of a sudden, all the bailiffs came sort of running out of some back room. They went over and told all the attorneys, and then all the attorneys went to the bathroom. So it's like that was our sign that the verdict was out.
They all went to the bathroom because they might be in for a while, and
exactly, because then they're going to go into
or hold it for 2 hours.
So we're hoping to sort of maybe get to witness the same thing here.
Okay. As far as jury deliberation time, how long have they been deliberating now?
When did they? I think around 12:30ish, maybe a little before 12:30. So probably about a half an hour now at this point, I think.
Okay.
I don't know if you saw, but they took their lunch orders earlier.
Mm-hmm.
They took a break during the morning break. So that's where we sort of learned that they were going to get the case for sure before lunch.
Yeah.
And during the jury instructions, the judge did say you can either take a break and eat lunch first, or you can just start while you're having lunch. So I don't know. I predict they're.
Yeah, it's like who can eat and write at the same time? You're the foreman. I think that's what they're doing.
Yeah. Oh, the one thing, I don't know. So we did observe is the alternates. So of the 15 that were there were only 3 men. 2 of them got picked as alternates. So there's only 1 man left. 14 women.
So it's almost an all women jury.
Yep.
Wow. That I've never seen the numbers skewed that way, one way or the other. That's pretty interesting.
That was a bit odd.
Now, was it like a random drawing, like bingo?
It was random drawing by the judge. She said a little, I don't know, put numbers out of a bowl or something.
Well, that is pretty cool. Lee, thank you so much. You saved us because we lost the video completely. We're in verdict watch right now. Hopefully we'll have early this afternoon a verdict. If you can give us a buzz on the burner phone like they did right here as soon as you hear something, I would appreciate it.
Yep, will do.
And thank you once again. Appreciate you.
Yep, thank you.
All right.
Bye-bye.
Bye. Lee and Shells are awesome. Pants is up there as well. We've got all sorts of Pants says it's the jury's case now, and that was at 12:43. So it's somewhere between 15 and 20, about 20 minutes of deliberation time has gone on. Depends on the count. Notice he didn't quite shave today. Yeah, I'm seeing how long I can grow it out before Mrs. R.A. says either you shave or you sleep on the couch. So I'm not sure when that's going to happen. Probably very soon. But I imagine tomorrow there will be no beard. Okay, so here's where we are. We have followed. We followed Cynthia and James in Judge Cedric's courtroom. We're in verdict watch for New Hampshire versus Adam Montgomery. We are ready to begin the Scott Peterson trial, which is opening statements. If you want, I can sleep in the new car. Yes, and then we have movie night in the new car. We could do that. Thanks, Thomas, for suggesting that. I'll make sure I take the keys out with me as I get kicked out. Apparently not everyone went down because I'm watching it on Jester's feed. It just backed up and I'm seeing pros closing. Yeah, it was just this one maybe, but I'm fine. I'm okay with it. It was dragging. Are you guys okay with it? Yes, we're watching the Scott Peterson trial. Not that Scott Peterson. Not the one that was accused of killing his wife, but the Scott Peterson who was the school resource officer who was responsible for the safety at Parkland, where the school shooting occurred. All right, so let me get that. You've been waiting on that. Okay, we're going to get that ready here. Let me stop and restart. Is that okay? We're going to call this lunch. Is that okay? Give me half an hour, and we'll switch over to the other one. Let's do that. That'll let me reset things because things are a little bit weird here. Feeds are dropping when they shouldn't be. We've had some buffering issues. I'm blaming 80s Music Man, who was probably busy editing out all the swear words we heard this morning. That's why he was distracted. It's a fun day. We're going to be right back in a little bit. So grab yourself a little bit of lunch. We'll open up a new window for the new trial. I still have to make a thumbnail for that one. I'm a little behind on that one. Great thing to do on lunch is watch one of Matthew Harris's videos. Maybe watch 2. Hey, while you're there, 5 of them. You know, you've got time. They're quick. How much time is Adam looking for at the gun offenses? I think up to 30 to 40 years in prison. They're not joking around about these as a convicted felon. Okay, all right. Tonight, when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again, which will be about half an hour. Give us 1:30. 1:30 we'll pop up here. We're going to catch up on the Scott Peterson opening statements. This is going to be our new trial we're following. We might stick some other trials in there as well because this will be a long one. We might have to take little breaks and then catch up on what we miss. But we'll figure out and we'll be in this together. Thank you very much, everybody. We'll see you here in a little bit. Bye.